Extension of interim order, my lord.
Extension of interim order, group 8.
Group 8 matter. Another is application, my lord. Same
What application?
application for stay.
Application for
Stay,
stay.
my lord.
Same
File
matter.
line, no, my lord. Another matter. File line in court, my lord.
Okay. You filed separate application for stay.
My lord.
Okay.
My lord, may I permit to make a mention? My lord, an appeal preferred before your lordship arising out of a motor accident claim, your lordship. Lordship passed the direction and adjudicate the dispute and settle the compensation amount, your lordship. But that compensation amount was your lordship a direction to pay within 6 weeks from the date of the order, your lordship. My lord, I am for the insurance company, your lordship. My lord, check was prepared, but your lordship could not hand over within 6 weeks. We could not hand over within 6 weeks, lordship. I am praying for at least keep it on to be mentioned, your lordship. So you can extend the time for hand.
I don't have determination now.
But your lordship passed the order, your lordship.
I may pass the order, but at present I don't have the determination.
So
Any order passed by this court would be out of jurisdiction.
My lord,
You understand?
Yes, your lordship.
You move before the
But your
appellate court
lordship,
bench.
lordship, with due respect, your lordship, so far my practice over here, lordship, the lordship passed the direction. The lordship has the only authority to extend the period for to hand over the check, extend the time for handing over the check, your lordship, because the lordship passed the direction, my lord.
I may have passed the several direction on each matters. Now I don't have the determination, so that can be done.
Lordship, then
Specific bench is there.
lordship, then I lordship mentioned before the lordship. Then your lordship, if your lordship, the
Yes.
Disney lordship not allowed the lordship mention again,
Yes.
your lordship. Grateful lordship.
Lordship, may I permit you to mention one matter, Lordship? Lordship, the West Bengal Government Food and Supply Department appointment of FPS dealership. Your petitioner applied for the post. The private respondent also applied for the same. Petitioner fulfilled all the criteria for the purpose of the FPS dealership, but due to some unknown reason, the FPS dealership was issued in favor of your private respondent. Lordship, the private respondent had not fulfilled the several criteria. The private respondent obtained the license by fraud. The appointment of the private respondent.
What is why you are here?
Lordship, please.
Why are you mentioning this matter?
For
hearing?
Yes, Lordship.
For hearing, for inclusion in the list?
No, for upgradation, Lordship.
Upgradation, what is the list number?
Lordship, item number 53.
Item number 53.
Yes,
What is the urgency of this matter?
Lordship,
Without urgency, no matter can be upgraded.
the appointment of the private respondent as a FPS dealership is based upon fraud, Lordship.
Very well.
Which is committed by private respondent, Lordship.
Very well. So what is the matter about? What is the urgency? You have prepared the read. What is the urgency to upgrade this matter? I am regularly taking the group 8 matters. There are some pattern matters. That's why what is the urgency? Without urgency, I cannot upgrade. What is the urgency? All the matters, the similar claim are there. So what is the urgency in this matter? Whether there is any stay? No, very well.
The license is fraud, Lordship, which...
Very well. Have you preferred any interim application?
Lordship, I don't have further
instructions. Okay, very well. Come on, next day.
My lord, may I be permitted?
Kindly, Lordship, please...
No, upgradation only be done in case of urgency. Without urgency, upgradation cannot be. It has been listed, so it would be taken up. No issue.
My lord, may I be permitted to mention for inclusion of 2 hearing group 6 matters, my lord? I'm grateful, my lord.
All on Friday.
Great.
My lord, for hearing matter group 6 inclusion.
Okay. How many matters, sir?
2 matters.
Okay.
My lord, upon notice, my lord, group 6 hearing matter.
Lordship, upon notice, group 6 hearing matters.
Group 6 hearing.
Group 6.
Grateful, Lordship.
All group 6.
Group 6 hearing.
Yes.
My lord, item number 1 and 2, my lord, I am appearing. My lord, with respect to item number 1, that has erroneously appeared. My lord, that was not mentioned yesterday. My lord, we had mentioned only the writ.
That was detagged and disposed.
That was detagged since your lordship had already disposed of the criminal revision.
Yes.
My lord, so 1, my lord, no order may be passed. With respect to 2, my lord, there are certain typographical errors, and my lord, with respect to the portion where your lordship has extended the
Order
interim
dated,
order,
the order
that
dated,
is order dated 27th of June,
Yes.
2024. My lord, here if your lordship
Put me
kindly
to that.
turns to page 2, the first paragraph is the writ number.
Second paragraph.
The second paragraph is the writ number WPA number 4652 of 2012. My lord, that number has gone down erroneously in the fourth paragraph. And my lord, it is the interim order.
Yes, yes, I understand.
Yes, my lord. And my lord, the interim order passed in connection with WPA, it is not that, my lord, it was CRAN 4.
And
Connected
4
to
arising
W-
out of WPA.
Connected to WPA.
Can 4
Yes.
Arising out of
Out of
WPA.
WPA
My lord,
4652 of 2000.
Obliged.
yes, my lord.
Obliged.
My lord, this is the initial order which was passed. This
I
was
understand.
ঠিক আছে
I-
মাইক
I
তোর
know.
কাছে আছে সব
I know interim matter.
only that much.
Please take down.
ওগুলো দিতেই হবে দেখো বড় বড় কই?
The item number 1 has been disposed of, so it was erroneously listed. Next para. Item number 2. WPA 4652 of 2012. Full stop. This matter appears for correction in order dated 27/6/2024 at page number 2 in 1, 2, 3 in fourth paragraph. The WPA number should be correctly read as WPA 4652 of 2012.
না না ওরকম না করে না
Correction করতে না।
Can number
4
Can number 4, my lord.
4 of 2023 তাই তো
No.
না 2023
4 of
4 of 2023.
হ্যাঁ
Okay. After the correction of WPA 4652 2012, the rest portion should be added as hereunder.
ব্যাস।
In connection of specifically within specifically in Can 4 of 2023 during invert comma session. So it appears, it would be read as interim order passed in connection with WPA. It would be read as interim order passed in connection with WPA 4652 of 2012, specifically in Can number 4 of 2020.
Most of
My lord, I was just thinking one thing, if perhaps if this suits. My lord, interim order passed in connection with Can number 4 connected to WPA. I think that will
That
make
will be
it
better.
easier.
Okay. Then do it another way. Okay. This matter appears for correction portion. Okay.
নিজের উপর
পুরোটা কাট। এই প্রশ্নটা here and here and no. Add with inches. The fourth paragraph should be omitted, and in its place, it should be read as interim order passed in connection with Can 4 of 2023
Connected to
connected
WPA number.
to WPA number 4652 of 2012
My lord.
during the pendency of both the matter be further extended till 6 weeks or until further order, whichever is earlier.
Well,
This portion would be added.
much obliged.
ওইটা এই fourth paraটা তুলে দেন, এটা করা।
In item number 3, my lord, on last Friday, my lord, I have appeared, my lord, on behalf of respondent number 4, which was, my lord, transfers from the, my lord, order also, my lord, but name is, my lord, not been given. The problem is that, my lord, unless my name is there in the order sheet, my lord, I
understand.
I cannot raise my bill to the department and cannot make the communication also, my lord.
Your name is
Pinaki Bhattacharjee
Pinaki Bhattacharya.
for the respondent number 4.
Respondent number 4.
4. Auditor General.
Down. This matter appears for correction. It appears that the learned advocate, Mr. Pinaki
Bhattacharjee.
represents respondent number 4.
Or Auditor General.
Before this court on 28/6/2024. Full stop. Erroneously, the representation was not mentioned in the order itself. Accordingly, the order dated 28/6/2024 be corrected in respect of the representation of respondent number 4 by Mr. Pinaki Ranjan Bhattacharya.
Pinaki Bhattacharjee. No,
Pinaki
Ranjan, my
Bhattacharya.
lord.
Pinaki Bhattacharya, learned advocate.
Petitioner is also, my lord, there, my lord.
Okay.
And I'm for the petition.
I have informed him.
Okay, very good.
Number 4, my lord, I am appearing for the respond number 6, my lord. My application on my instance, my lord, the matter is appearing before your lordship. On my instance, the application is appearing before your lordship, my lord. Now, my lord, this matter was taken up before your lordship on 27/6/2024, my lord. Now, my lord, in the second half, my lord, and my lord, I beg apology for your lordship, my lord. I couldn't appear before your lordship at that point of time due to some medical reasons, my lord. Now, my lord, they sought a time for 3 weeks for reply against an exception to a report which has been filed before your lordship. I am not standing in that way, my lord. They may get that time, my lord. But they have sought for 3 weeks time, my lord. My lord has granted that 3 weeks time. I am not standing in that way, my lord. But my lord has adjourned the matter till 29 July, my lord. I am only praying for preponing of that date, my lord, because, my lord, there is a specific division bench direction, and on that score, my lord, a CAN 4 is pending, my lord. Now, my lord, in that, there are 3 weeks I have calculated, my lord, that 3 weeks should end on 15 July. If the matter can be fixed on 15 July or within 18 July, my lord, then the division bench directions also gets complied with, and my
Petitioner was given liberty to file the
exception
within
3 weeks.
3 weeks.
I'm not standing in that way, my lord. I'm just saying that, well, in spite of 29 July, the matter may be preponed back, my lord. First of all, my lord, I am
urgency.
Well, my urgency is my license is being suspended by the order of this, by the interim order passed by this honorable court, my lord.
So that has to be
Sorry,
whether,
state.
whether that can be done on that day without hearing of the
My
parties.
lord, if they file the exception, my lord, the matter gets complete and my lord, the matter can be heard out.
It is pressure upon the petitioner or any why.
No, my lord, it is not a pressure. I am just praying for preponing of the date, my lord, because
If we prepone the date, whether that would be disposed of without the
my lord, they are getting 3 weeks time for filing the exception, my lord.
So
After 3 weeks only, 15
when
July,
3 weeks?
15 July is expiring. From 26 July,
June.
from 26 June, the 3 weeks is expiring 15 July.
Who is for the state? Yeah, for the state.
If it is a Monday, it is a 15 July. If lordship takes it on Monday, and if lordship takes it on literal sense, it ends on 18 July. My lord kindly fix the date on 18 July. I am not standing on the 3 weeks time they get.
Then come on 22nd.
As your lordship.
Not earlier than.
My lord,
Okay.
then my lord kindly at the top, my lord.
How can it be made top?
My lord, because the thing is that my lord kindly
No,
cease.
no, I have already fixed the top matters, parted matters. It is not a parted matters. Unless the parted matter is disposed of, what is the possibility
My
of?
lord kindly seize the CAN 4 once. Kindly seize the CAN 4 once.
I understand you have prepared a CAN 4 for vacating of the interim order.
No. CAN 2 is my vacating of interim order. CAN 4 is for expeditious disposal with the, and it is supported by a division bench order, my lord. Kindly seize the CAN 4 once, my lord. Kindly.
Come on 22nd.
My lord.
My lord, at the top, my lord. Kindly, my lord. Kindly seize.
Top cannot be done like that at the top. You know that there are some parted matters.
Because this matter was running at the top before Justice Patnaik, my lord, it was running at the top only, my lord.
Only parted matter can be appear on top.
My lord,
Let it be heard first, thereafter it will be coming.
my lord.
Once I take the hearing, thereafter it will be altogether. Like,
For the respondent number 7, I want to file eligibility reply.
you are for the respondent number?
7, petition number 3901.
There are 3 read petitions. Acha. Please take down. This matter appears under the heading of to be mentioned. On behalf of respondent, private respondent.
Respondent number 6, my lord.
Private
There are two
respondent number
private
6.
respondents, my lord.
Learned advocate appearing on for the private respondent number 6 submits that the hearing date of hearing was fixed on 29 July 2024. There are urgency in this matter, so the matter may be preponed. Considering the submission, the matter be preponed and fixed on 22nd July. Within specifically within first 5 matters
My lord.
of that list of the days list. Full stop. Next para affidavit in reply filed on behalf of the respondent number 7 is taken on record.
My lord, can I pray for one extra indulgence, my lord, if your lordship?
Within
Please.
first 5 matters.
My lord, they may pause because your lordship directed the state. It was your lordship's direction because your lordship directed the state. My lord, the report came up because your lordship just added a word positively. The report came up after 3-4 adjournments. The report came up from the state. If your lordship kindly directs them to file the exception positively within that date, my lord, the exception may come up.
Wants everything, my lord. When the matter was called out, it was not present.
All order is there to file. They are given liberty. They are
My
not
lord,
taken away the liberty right now.
He missed the bus on last day. He was not present. Now he's saying so many things.
I pray for apology, my lord, for that.
Very well. Already order is there. Specific direction is there. How can I alter?
Lordship.
Yes.
Lord, this is at my instance for extension of interim order.
My lord, may I file my affidavit in opposition?
Yes.
If they have served the copy, although way on time, I pray for time, extension of time to file the exception. Hey, opposition this
Report.
total exception. I'm paying for 3 weeks time to file my exception.
Report in the form of affidavit filed on behalf of the state respondent number 1 to 5 be taken on record. Full stop. Petitioner is at liberty to file exception, if any,
3 weeks. Oh.
within 3 weeks from date. Full stop. Next part. The petitioner seeks for extension of interim order. Full stop. It appears that the interim order was passed by this court on 3rd of May 2024. It further appears that the matter is otherwise ready for hearing as the state respondents has submitted the report. And what about the other private respondent?
There is no private risk.
There is no private respondent. Very well. Let the now considering the entire circumstances, let the interim order passed by this court on the earlier occasion, that is on 3/5/2024, is hereby further extended till 20th August 2024 or until further, whichever is earlier. Let the matter appear in the list on 6th of August.
My lord, may it appear towards the top, my lord, so the hearing can be expedited.
No, I do not know whether it would be appear on top because there are running parted matters are there. Only parted matters are on top. If there is urgency, you can mention it. I can put it on top.
Because my
Matter
lord,
to appear as for
it
hearing.
enjoying an
Hearing.
interim order, my lord. That's why we would have wanted
So
to.
that's why I have fixed the date earlier to the interim order so that the matter can be disposed of.
Grateful.
Matter to appear for hearing.
Under the heading hearing. Yes. Yes.
My lord, this is a repetition challenging and order of termination by the.
Have you served?
My lord, all served and the notice of mentioning has, I have, prior to mentioning this matter, I have also informed that 24th I mentioned, my lord, 21st I gave it. It's the last page, my lord. Page 13, my lord. I have given that.
However, you have mentioned the judge's name incorrect
My lord, let me correct.
in the letter. However, okay, get the case. What is the matter about?
My lord, the matter is about the termination, which a termination of a dealership of a license FPS dealer, my lord. Fair price shop dealer. That has been one inspection was done. The inspection report was never been handed over to the writ petitioner, my lord. Thereafter, there are series of charges, my lord. At page first, my lord, at page 17 is a initial suspension order wherein the charges has been
Cause notice.
show cause, my lord. The reply was given, my lord. Thereafter, the first order, whereby in the first order on the prima facie, without any reason, my lord, the dealership was terminated, my lord. I shall draw your attention and seek your pleasure of your lordship that there are two. Kindly come to the ordering portion, my lord. Only come
Page
24 to 27, my lord.
Yes.
Page 24 to 27, my lord. Kindly from 24, the charges are only repeated, and thereafter at the ordering portion, all perusal and replies of at page 27, bottom. On perusal of replies to the suspension comes show cause notice and oral submission before licensing authority during personal hearing. I am of the considered opinion that FPS dealer was grossly violated provision 26(4), 26, 26(4)(b), 26(4)(c), 26(4)(d), and all. And condition number 1 of the license, in view of the above, by rationing officer Jadavpur under DDR Kolkata South, licensing authority found licensee guilty for violation. My lord, there was prima facie, there was no reason. And thereafter, my lord, it was the writ petitioner thereafter admitted that only the shortage of stock, to the extent he admitted to that charge. My lord, considering that, even if I assume that if he admitted, my lord, then my lord, it could have been that regularized by the imposition of punishment, my lord, at the age of 70, my lord. And moreover, thereafter he filed an appeal at page annexure P4, page 29.
Preferred appeal
Appeal
before the appellate authority.
before the appellate authority.
First appellate authority.
First appellate authority.
Yes.
That appeal also been turned down again by one line order, my lord, at page 36. Considering all the aspects made in submission during personal hearing and perusing the order of rationing officer Jadavpur 1, appellate authority amiable in terms of para 30 of WBUPDS M&C order 2013 to be read with subsequent amendment, hereby upheld the order by the licensing authority that this rationing officer quite dated 24th June 2022.
Yes. Thereafter, what? you have done?
Thereafter, I preferred a second appeal, my lord. Thereafter, I preferred a second appeal. That second appeal was again dismissed in a similar order.
Where is the order?
Order is at page 42.
Page 42.
Page 42. In view of the second and final authority, it is my considered opinion that the termination of the appellant's FPS license by the licensing authority RO Jadavpur, which had been upheld by the first appellate authority, that is Deputy Director of Rationing, Kolkata South, was just and appropriate, giving serious irregularities found. Consequently, I hereby uphold the order of first appellate authority, that is the Deputy Director Rationing, Kolkata South, which terminated the FPS license and the appellant of the appellant. The appeal is thus disposed of. Thereafter, my lord.
Your Lordship, for the state, Your Lordship, led by Advocate Abhishek Prasad, Your Lordship, I'm praying for a Passover. He is currently engaged in court 18, Your Lordship.
I have started the hearing.
Please, Lordship,
Let him come, my lord. Let me place. I need some time, my lord. Let him come. Let me continue.
may please to fix it anytime today, Lordship.
Today I have some specially fixed matter at 3. Second half not possible.
Lordship, I fix tomorrow.
Okay, tomorrow on the same heading?
Tomorrow on the side.
Same.
Tomorrow. Not today.
Item number 9, my lord.
Item number 9. Lordship, I appear for the petition, item number 9, my lord. My lord,
Yes.
it is a similar writ petition, my lord, wherein, my lord, orders have already been passed by your lordship, my lord. But I'll tell you, lordship, my lord, orders happened here. But I am challenging certain notifications, my lord, and including, my lord, the notification whereby, my lord, certain beneficiaries, my lord, would be, my lord, a new vacancy has been declared, my lord, in the same Moja and same Gram Panchayat, my lord, where, my lord, I am already operating an FPS shop, my lord. Lordship will find, my lord, the notification at page 27. Lord, I have, my lord, 7545 beneficiaries, my lord.
Yes.
So, my lord, yes, my lord. Now, lordship, my lord, if your lordship sees, my lord, junior would hand over, my lord, orders passed, my lord, in WPA 14721, my lord. Exactly the, my lord, the same fact, my lord, where, my lord, the notifications dated, my lord, 3rd September 2021, 11th February 2022, and 28th March 2023 are under challenge, my lord, where, my lord, the control order, under control order 2013, my lord, vacancy has been declared. But I was praying, my lord, for similar order in this case as well. But my junior is there, my lord, with that order, my lord, and there are several orders that passed by your lordship himself, my lord.
সেটাই তো বলেছি
You are FPS dealer for the Moja for area.
the notification, but they shall not.
What is your location?
Lordship?
Is the petition a MPS dealer?
Yes, my lord. Yes, my lord. FPS, my new vacancy has been carved out, my lord, from the same region, my lord, where I am operating as an FPS dealer, my lord. Lordship will kindly see, my lord, the order, my lord, that my junior is standing there with, my lord.
Yes. What is the issue? In the same Moja, in the
Well, I
same
think-
location,
I think,
another.
my lord, it is so. I think it is so. It is Pakuria. Pakuria 113.
Pakuria 113.
And well, this petitioner is running. I think.
FPS dealer shop. Running dealer shop.
In Pakuria.
In Pakuria.
PO
Pakudia, yes.
Devipur, Devaipur,
Yes.
ward Saralpur, district Murshidabad. Yes, GP ward Saralpur,
Yes.
same.
Now, my lord, here, my lord, the same allegation that they are apprehensive of curtailment of the
They have
volume of
not-
business.
They have not annexed the order wherein the number of ration has been decreased.
Decreased and the
The-
curtailment there is a in 24 paragraph 24 page 8 they have said authorities sought to curtail the petitioner's volume of business.
Yes.
But there is no specific, I mean, the details about how and in which
Yes,
manner
what
and
is the order?
how many ration cards will be detagged or something of the kind. That has not been specified in the petition. So the details are lacking. But my lord, yes, yes. They will not suffer any prejudice, just apprehension that they will lose the volume of business. That's the only allegation. But then, without if they come with a specific, my lord,
Yes, where is the order?
the order, your lordship, they have one order of your lordship.
No, that is the order is passed regarding the volume of the, in this matter, the volume was decreased.
Lordship, lordship, I just.
25 and 26 they have said it. No, in this writ petition, in WPO 14721, two orders dated 11/2/2022 and 28
March
2022. There are two separate orders were challenged, where the business was
reduced.
That is the challenge before this. But
Yes.
in this case, there is no
It is
such
not
challenge.
there. So, well, let them come in a supplement with the details.
Yes.
Your lordship can pass the order. Huh?
Where is the order?
Page 25, my lord, I just assist your lordship, my lord. Page 25, I understand.
I have annexed all the notifications, my lord.
Page
In fact, I've
25,
challenged the notification.
11th
If your
February
lordship sees, my
2022.
lord,
Okay, order
my
is there.
prayer A.
Well, it is there, my lord. It is there. Subject to
Okay, got it.
page 25 is the 11th February 2022 order.
Very well.
It is there. And the same order I find is challenged in the other petition.
Yes. Two orders, similar orders are there.
Yes.
28th of March 2023 and 11th of February 2022.
Lordship.
Very well.
Affidavit দিতে বলেছে।
What is the affidavit of service?
Lordship.
Only the state authorities that parties here.
Yes.
ঠিক আছে। লাগবে।
Take down
1/4.
affidavit of service filed on behalf of the petitioner is taken on record.
Ramanan. No,
The present petitioner is running a fair price shop under the license of the government of West Bengal at Mauja Pakudia, PO Devaipur, Ward Saralpur, District Murshidabad. Full stop. Next para. The present petitioner had challenged two orders passed by the Director, District Distribution, Procurement and Supply, wherein dated 11th February 2022 and 28th March 2023, wherein the government has decided that 6,500 ration cards will be considered as the average population to be retained with an existing fair price shop. It is the case of the present petitioner that the policy adopted by the fair price policy adopted by the state would hamper the business of the present petition. However, learned advocate for the petitioner submits that the notification was issued for the vacancy in respect of the same location on 30th of November 2023. He submits that the vacancy notification was issued by virtue of West Bengal Public Distribution System within bracket Maintenance and Control Order 2013. Order Maintenance and Control Order bracket close 2013. Full stop. He further submits that the said control order is under challenge before this court in several lead petitions. The matter is yet to be disposed of. So till disposal of the said issue, he prayed for necessary order of stay of the impugned notification dated 30th of November 2023. Full stop. Mr. Dotto, learned advocate, appearing on behalf of the state, submits that the order passed by the Director District Distribution, Procurement and Supply is a policy decision which cannot be challenged in a writ petition. Moreover, the West Bengal Public Distribution System Maintenance and Control Order 2013 has not been declared ultra vires by any of the court. Thus, the present petitioner are not entitled to get any interim order. Further, learned advocate, it appears that after promulgation of National Food Security Act 2013 and Delegated Public Distribution within bracket Control Order 2015, the Impugned Control Order 2013, on the basis of which the vacancy has been declared, has become redundant. Full stop. However, the matter is under active consideration of this court on several lead petitions. Thus, at this juncture, to avoid the multiplicity of proceeding, it appears to be justified to pass an appropriate order in favor of the present petition. Full stop. Whether the matter has been disposed of or not, this is no. Okay. No. The parted matter already heard several matters, but but it was reserved. Judgment reserved. Considering the above observation, the vacancy notification dated 30th of November 2023 be stayed till 8 weeks from date or until further order, whichever is earlier. Full stop. Next para. The order of stay shall not forbid the state authority to carry out the proceeding as per notification, but they shall not finally commission the license without the leave of this court. Without the leave of this court.
Yes, my lord.
What is at liberty to mention? Full stop. Next para. The state is at liberty to file affidavit in opposition within 4 weeks.
Yes.
Reply thereof to FNA by the petitioner within 2 weeks thereafter.
Only one submission that I was making. Lordship, the impugned order is dated 30th of November 2023.
2023.
Yes, they are coming in June. I mean in July. Today is 3rd July. So kindly, my lord, they add one line so far as the state is concerned that there is a delay in challenging the impute. Yes.
Notification.
Yes. And I'm not admitting the allegations made by him. He has made, recording some submissions of the petition. I'm not admitting any of them.
Okay. For the state, যেটা বলেছি দেখো এখানে add করে দেবে Mr. Dotto, learned advocate for the state, further argued that the present writ petition is preferred beyond the statute preferred with an inordinate delay. Full stop. The impute notification was passed in the November 2023. Now the writ petition was preferred in this month of July. Full stop. Thus, he further submits that the state has denied entire allegations made in the writ petition.
Obliged, my lord. The only thing is, my lord, it was preferred in June, not July, my lord, June. That's the only correction.
Okay, next.
Nothing else.
Yes. Yes. Give me your name.
Item number,
Yes.
my lord, item number 10, my lord. My lord, item number 10, my lord, I am appearing for the petitioner, my lord, but I'll be seeking, my lord, a day's accommodation, my lord, praying for not today, my lord. The reason being, my lord, I'm barely able to hear your lordship, my lord. My connection is really very poor, my lord. Lordship, can you take it up tomorrow, my lord?
But you will not today.
Obliged, my lord. Keep your pleasure.
But I'm appearing for the 8, 9 and 10.
But already our part has been completed. Let my learned friend start.
Let me hear the state first.
The state itself.
State is respondent number.
File the affidavit, lordship, report.
5 and 6.
Other than 6, lordship, respondent number 1, 2, 3, 4, 5, and 6. But 1 to 6.
1 to 6.
But respondent number 6, who is the main answering respondent?
Very well. Yes.
The affidavit has been filed by respondent number 6, lordship, and as per the direction of the on 8th day of August 2023. Lordship, your lordship has already gone through the previous, your lordship has gone through it, that as per the direction of the honorable court in the appeal, inquiry report has been prepared. And lordship, I'm coming from that point. I'm not going to the previous point, I'm coming to that point. And inquiry has been held on 27th April 2023. And such report is being annexed with my affidavit, page number 10. First of all, lordship, I'm coming to the point dealer. Is what the dealer. As per the dealer, what fair price shop owner means a person and includes. Lordship, I'm reading from the lordship, who is called a dealer.
Rule.
Lordship,
Definition of ruler.
definition of dealer. Rule 2H.
Rule 2H. Dealer.
Dealer or fair price shop owner means a person and includes association of persons or a registered cooperative society or a corporation or a company or a registered self-help group or any other legally constituted body in whose name a shop has been licensed to distribute and sell public distribution commodities through ration card orders under the public distribution order issued under Part 3. So as per the rule, Lordship, the dealer was Satish Chandra Das,
Yes.
under whose name the fair price shop was being licensed.
Yes.
Thereafter, Lordship, I am coming to Rule 20, Lordship. Rule 20, Lordship. Rule 20, Lordship, engagement of a dealer. How a dealer can be engaged. In the event of resignation of any dealer,
Rule 20.
engagement of dealer.
Engagement of dealer.
In the event of resignation of any dealer, death or incapacitation of the existing individual dealer on medical ground, unless any of his or her family members is found suitable for engagement on compassionate ground, as per subclause 6, dissolution of or cancellation of license. I'm not going into that because our thing is depending on 20B. Death or incapacitation of the existing individual dealer on medical grounds, unless any of these or family members is found suitable for engagement on compassionate ground as per subclause 6. Lordship, I'm taking a pause over here. Lordship, Satish Chandra Das was the registered dealer who at his lifetime under the medical ground prayed that his son Ajit Kumar Das to be given the dealership. And as per rule, he has filed one affidavit, first class magistrate affidavit for transfer of FPS dealership on compassionate ground. He has filed one non-judicial stamp paper. There was an affidavit. I don't know whether it has came before your lordship or not, but this document I got it later, lordship. This is a document I just want to show your lordship, just for your petition, lordship. Just at a glance.
Now it has no effect as before the decision he has expired.
Opposition also, they have not given.
Going into that, I'm just showing before your lordship that this was one affidavit that was been forwarded by the deceased Satish Chandra Das at his time, at his lifetime. This was an affidavit. So we are concerned about two things. At the time of death of Satish Chandra Das, who was eligible for the dealership. For concerning on this part, I am just showing before the lordship. Lordship, so at the time of lifetime of the Satish Chandra Das, he has forwarded such affidavit, and on the basis of that, there was an application made by his son and Ajit Kumar Das for dealership. But such application has been rejected on the ground of, but such application has been rejected on the ground, not rejected, but it has become infractuous after the death as Satish Chandra Das has died on 8 March 2017. Lordship, this is one aspect I'm taking, Lordship. Next, Lordship. So typographical error, Lordship, will be 18 March, but in my report it was given 8 March. So I'm being apologizing, Lordship. This is what. So at the time, so this why I am placing this, Lordship, that at the lifetime of Satish Chandra Das, there was an affidavit, and as per 20B, there was a ground that such can be done. Lordship, next I am coming to the compassionate ground. Thereafter, I will come to my report, Lordship. Compassionate ground, Lordship. Clause 6, Lordship. Rule 26. Engagement on compassionate ground. In case of vacancy arising out of death or in case of incapacitation on medical grounds, subject to satisfaction of the authority or any existing dealer, such vacancy shall not initially be notified. Prayer of any of the family members of the deceased incapacitated dealer having no regular means of subsistence. Lordship, I'm pausing here again. Incapacitated dealer having no regular means of subsistence will be considered with preference on compassionate ground, provided such prayer along with formal application in Form C along with annexure. One with requisite fee is submitted within 60 days. Here I'm again pausing. Then I will come back to my report, Lordship. First I'm going to the rule, Lordship. While applying, applicant shall have to furnish. Again, I'm placing this word, Lordship, shall have to furnish no objection from other family members in the form of an affidavit executed before a first-class magistrate, except in the following cases. If the applicant is a spouse of the deceased licensee, if the ex-licensee, because of his or her being incapacitated, inform has opted for the applicant. The subdivisional controller, food and supplies, shall arrange for an inquiry to verify the eligibility of the applicant and submit the report with his opinion to district controller, food and supplies. Subdivisional, Lordship, I am reading once again, Lordship. The subdivisional officer, food and supplies, shall arrange for an inquiry, Lordship, for an inquiry to verify the eligibility of the applicant and submit the report with his opinion to district controller, food and supplies. While forwarding a case on medical ground, subdivisional controller should satisfy himself or herself on examination of medical prescription and certificate issued by registered medical practitioner that its licensee was not in a position to run the dealership business considering his or her health. District controller, food and supplies, and forward the same to the state government, to the director of DTP, and as per necessary approval. The subdivisional controller, food and supplies, having government approval, shall issue an offer letter in Form D with the approved candidate directing him or her to furnish the recent passport. So these are the as per the rule, Lordship. Dealership run by any individual person shall not be allowed for. This is rule 7. That is, I'm not. So these are the two things I'm placing over here, Lordship, from rule 6. That an inquiry have to be held, and no objection certificate have to be to get a no objection certificate for compassionate ground. Lordship, now I'm coming to my opposition report, Lordship. This report, Lordship, I'm coming to each para, Lordship. Each para, Lordship, where I have described the Lordship the thing. Lordship, kindly come to para number 4. Lordship.
Just wait.
4. All the para, sub-paragraphs 4A are studying, Lordship. Shipshong of that, I definitely follow that. Shipshong of that.
Okay, just wait. Let me find out.
What the
Paragraph?
Paragraph number 4A.
Opposition.
Opposition filed by state.
Affidavit in opposition on behalf of respondent number 6. Lordship, kindly.
Response number 6. Yes.
The Shipshong for Das, whose father name is, let's position the Das as a name. Such code number under the village such as that was expired. Or Lordship, the date may be 8, but typography may be 18. His son, Shipshong for Das, applied for transfer of alias license on compassionate ground. Death in place of his deceased father. This application came after the demise of Shotishong. Shipshong for Das filed an application for grant of license on compassionate ground on 21st April 2017 with an application fee of 30 lakhs. At the time of said application, dated 21st April 2017, Shipshong for Das was the SKO retail license in his name. The license number is which indicates that he was employed at the time of making application for grant of LPS leadership license of compassionate ground in place of his deceased father. It appears Satish Das during his lifetime made an application for transfer of dealership in favor of Pradeep Kumar Das on 2nd March 2016. Along with the application by Pradeep Kumar, C and TR challan amounting to 1,000 on account of such application P and inquiry in respect of application was made by the area inspector, and in the inquiry report the status of Sajid Kumar Das was recorded as unemployed. However, before consideration of the said application, Satish Chandra Das died and the said application became infractuous. For that reason, Lordship, I have handed over this thing, Lordship, that is the epidemic of one. After the death of Satish Chandra Das, Ajit Kumar Das made an application on 17th May 2017 but did not attach the TR challan in respect of application B. However, TR challan was submitted on 29th May 2017. The fresh application of Ajit Kumar Das could not be considered because the application B was deposited after 60 days period. Moreover, Ajit Kumar Das could not obtain new conviction from other areas of the Satish Chandra Das. So two things. First of all, Satish, first of all, the brother Shiv Shankar Das has filed one application for compassionate ground, and his application was rejected that he was holding one license, kerosene oil license shop.
Where you have stated that his application was rejected?
Retail license in his name being number such and such, which indicates that he was employed at the time of making application for grant of SES leadership license on compassionate ground. And his thing has been rejected on the ground that
No, you have not mentioned that his application was rejected. You have not mentioned in your.
become infractuous on the date of the
No, in application become infractuous regarding the earlier application. Yes. Incapacitation. Yes.
that application he was not filed a TR challan.
By the Satish Chandra Das, respondent, private respondent. Ajit.
Was filed by Ajit Kumar Das, but without the TR challan.
Yes.
And therefore such application could not be taken into account.
Yes.
Lordship, kindly come, Lordship, there is no other record in the office to ensure that employment status of Ajit Kumar Das should not obtain no objection from other legal layers of the district Satish Chandra Das.
Yes.
The Lordship got it, Lordship.
Yes.
Next, paragraph number 4B. I say that Sri Shiv Chandra Das has submitted his application on 28/4/2017, which was forwarded to the area inspector Ranimat for detailed inquiry and report. The area inspector Ranimat has inquired the application and submitted the inquiry report. On scrutiny, it was found that several important documents were not submitted on the part of the applicant at the time of inquiry. At that time, file could not be possible due to the submission of no objection certificate from all other legal layers of Satish Chandra Das as mentioned in the legal layer certificate furnished by the Panchayat Pradhan of Panchayat Pradhan Gram Panchayat Company Ranibas dated such and such 5/4/2007, where it appears that Satish Chandra Das had 5 legal heirs: Madhav Chandra Das son, Shiv Shankar Das son, Tarapada Das son, Ajit Kumar Das son, and Mohammed married daughter. Several times reminder was issued from the end of Shiv Shankar Das, from this end Shiv Shankar Das by memo number 7. But Sri Shiv Shankar Das has failed to submit no objection certificate from all the listeners. That thereafter 6/9/2019 by memo such and such subdivisional controller and supplies Matra into the application has failed to produce verified document in spite of repeated correspondence, and hence this application was rejected. Thereafter the petitioner preferred an appeal. Shiv Shankar Das.
Yes.
Petitioner preferred an appeal before the Food and Supplies Bakura on dated 19/10/2020, and after hearing the petitioner Sri Shiv Shankar Das Bakura on 17/12/2020, after the petition of challenging the state order, the petitioner filed a writ petition before the Honorable High Court, which was registered on 2021. Shiv Shankar Das versus State of West Bengal. Petition was disposed by Honorable Justice Amrita Sinha Honorable Court on 5/8/2021, directing SPF Chhabra to grant 90 days time to the parties to submit the requisite document. SCFC provides opportunity of by member to submit requisite document, but parties fail to submit the requisite document within due time. In the meantime, two appeals being FMA 106 of 2022 and FMA 107 of 2022, it was Ajit Kumar Das versus Shiv Shankar Das were filed by Ajit Kumar Das, younger son of the deceased leader Sri Satish Chandra Das, and one of the applicants for licensure compassionate grounds. So, Lordship, now Ajit Kumar Das has also filed one appeal. On 11 March 2022, Subdivisional Controller President Dr. Bhadra was directed by the Honorable Division Bench to file a report from the Learned State Council as to the status of the nature of gainful employment of both the applicants. Status of the nature of gainful employment of both the applicants. I further say that in terms of the above direction given by the Honorable Division Bench on 31st January 2022, a report was submitted by the Subdivisional Controller FNS Bhadra where he stated that Sri Shiv Shankar Das was holding an SK oil license, which indicates that he employed at the time of death of his father. And as per inquiry report of area inspector against the application for transfer of license on medical ground due to lifetime of the Satish Chandra Das, Ajit Kumar Das was recorded as unemployed. Then appeals were taken up for hearing by the Honorable Justice Preponing and Honorable Justice Sharvishir on 3rd January 2023, where it was disposed of directing SCFC to dispose the matters considering the application of both the applicant at the night of the observation made in the judgment of that 8/42/2020. And that thing is that also annexed to the report. As per direction of the Honorable High Court, the hearing was conducted by SPFC and both the applicants, Sri Ajit Kumar Das and Shiv Shankar Das, by memo number such and such, specifically on at the chamber of SPFC. An inquiry was also conducted to find out the dependency of the legal heirs on deceased Sri Satish Chandra Das at the time of death in connection with requirement of pension. The matter was disposed and a present order passed by memo number such and such. Sri Ajit Kumar Das, son of deceased MR dealer Satish Chandra Das, was found eligible for license on compassionate ground. The order has communicated to all the now the inquiry report is annexed here. Let's finally come to the inquiry report portion, that is page number 10 portion. Lordship, as per the direction of the Honorable Court, Lordship, the inquiry has been conducted and the report has been filed, Lordship. So, Lordship, I am coming to the second paragraph. After field inquiry, Lordship, I am placing this word again, after field inquiry and interacting with locals of the area in the following observation. So, a field inquiry and interacting with the local people. Because I am placing here, Lordship, once again, my learned senior friends on the last occasion has stated that the report has been filed without having field inquiry. So, I am placing this word again, I am repeating. After field inquiry, interacting with locals of the area following the observation that there are 5 legal heirs to the deceased dealer, like Satish Chandra Das, namely such and such. Sri Ajit Kumar Das and Shiv Shankar Das and Sri Badal Chandra Das were present at the spot for inquiry. They are inside the house having different kitchen. Sri Tarapad Das and Sri Mamata Das were not present during the inquiry. Ajit Kumar Das and Shiv Shankar Das both were asked to produce of their financial stability document related of means of subsistence. Applicant Ajit Kumar Das has currently a grocery shop and the business is running in 2018. He informed that the business was run by his father when he was alive. He has produced trade license and GP tax receipt copy during the inspection of the inquiry. Shiv Shankar Das has currently a telecom Xerox shop and the business is running since 2018. He has produced trade license and GP tax receipt. Shiv Shankar Das had an SK oil retailer license at the time of death of his father bearing license number 7. Father Chandra has informed he is currently holding a license of SK Oil bulk dealership. Momodamoy Das is married and is residing permanently in Jharsuguda, Odisha, with her husband at the time of death of his father. Sri Tarapada Das, the practicing advocate of High Court, and was retired at the time of death of his father. As per certificate of Panchayat Proceedings, Ajit Kumar Das was dependent on his father, late Sutish Chandra Das, a FPS dealer, Ranipur, at the time of his death, and used to take his father. While arguing about if any member of his family is in government service, Ajit Kumar Das informed that he is not involved in government or private job. Our wife is working as second in a purely contractual basis and engagement owner in this regard, and where he is engaged on contractual basis. Lordship, what happened? Lordship, copy attached is written over here, Lordship, but at that time the copy was not being provided, Lordship, but later such has been given before the record, Lordship. On by the order 14th March, Lordship. After that, I have already given the copy that the wife of Ajit Kumar Das was working at ANM. Lordship, it is in the record, Lordship. Submission of engagement letter of Shrimati Das, wife of Ajit Kumar Das. Lordship, if your Lordship would take, Lordship, this is the letter, Lordship.
Yes, you proceed.
Yes. On asking whether he has any other business in the name of his family, Sri Ajit Kumar Das informed that he did not have any business on his name at the time of death of his father and currently has only one grocery shop to sustain his life. On asking about fertilizer shop, he says that he is not running the business, he has already closed for a long time. Sri Shiv Shankar Das is currently unmarried and is not involved in government or private job. On asking whether he has any other business in his name, he is right. As per land document, it is found that land is in the name of their father, Sutish Chandra Das, and still is not divided among the legal rights. Based on the above observation, it can be concluded that Shiv Shankar Das was holding a SKY license at the time of death of his father and was not fully dependent on it, whereas Ajit Kumar Das was dependent on his father as per GP Pradhan certificate and also documents found during inquiry. Lordship, next page is the GP Pradhan document, Lordship. So GP is not being party over here. Lordship, page number 30, Lordship, that is the English type, Lordship. This is to certify that late Sutish Chandra Das, son of late Chandra Das, was a permanent resident of village Sasinta, Bankura. He expired on 18/3/2017. Was an experienced leader. His younger son, Sri Ajit Kumar Das, helped him to run the FBS for a long time and even after his death. His only daughter is married and other three sons were engaged in different professions. His four sons resided separately. Sutish Chandra Das used to live with the family of his youngest son, Ajit Kumar Das. Sutish Chandra Das was dependent on his son. Ajit Kumar Das, at the time of his death, even he bore all his funds. Thereafter, Lordship, this is the recent order which passed on 29th May 2023. Lordship, page number 14, Lordship.
Yes.
Recent order passed in compliance of order passed by Honorable Justice of Calcutta High Court, Chittaranjan Das and Partha Sardeshan in connection with FMA 106/2022, Ajit Kumar versus State of West Bengal and others with FMA 107.
No, show me the order first. The direction of the order. Of the division bench. Refer me the page.
Lordship, the starting is from 119, Lordship.
That is 155.
This is Lordship. This is Mat 840. Yes. This is page 113, Lordship. This is FMA 106/2020. 106/2020. Lordship, what is Lordship? Page 113.
Yes.
Yes.
What is the paragraph?
Lordship, first it's done, Lordship. Lordship, kindly come to paragraph number 6, Lordship. Page number 115.
Yes.
Forthwith to notice all legal heirs of the deceased father of the present applicant appeared before SPFC, except the married daughters, as the legal heirs failed to come to a settlement in choosing a suitable applicant, and order was passed rejecting the applications by the present applicant and the present private respondent. The matter was carried in statutory appeal by private respondent. Shiv Shankadas filed a writ petition being numbered such challenging the order of the appellate office. The said writ petition was disposed of by this court, directing SCFC to grant 90 days time to the parties to complete the requisite document. Challenging the order dated 21st September 2020 passed by SCFC, the present appellant preferred WPA 9389 of 2021. The Honorable Single Judge disposed of the writ petition, directing the present appellant to submit no objection certificate within 90 days as per the order passed in the court in earlier writ petition, that is WPA 6286 of 2021. The said order passed in WPA 9389 of 2021 is the subject matter of FMA 106 of 2020. From the facts narrated, it is clear that two brothers have filed application for appointment as fair price shop dealer on compassionate ground. Appointment on compassionate ground can be given to one if said one is found to be eligible in all respects. So far as the requirement of filing no objection certificate is concerned, it has been held in the case of Guru Das versus State of West Bengal that no objection certificate by an appellant is required to be given from a dependent family member, and if any such family members are living independent from the ex-dealer, no objection from him need not be this is not given, Lordship. So page is not given, Lordship. Next, from paragraph number 10, Lordship, from the materials on record and submission advanced by the learned counsel for the parties, it is clear that the present case is fully covered by the judgment of Guru Das. Both the appeals are disposed of by directing SCFC Calcutta to process the application of the appellant and private respondent Shiv Das in the light of the observation of paragraph number 20 of Guru Das. Both parties with the order will make it clear that there is no need of coming to a composition by the intending party. The SCFC or inquiry shall recommend the issuance of license in favor of the person who is found to be suitable, taking into consideration the rival claims of both the appellant and the private respondent. Shiv Das into consideration. It is made clear that the application filed by the party shall be proceeded within the 90 days from the date of receipt of the order. The judgment included appeals are accordingly said aside and the appeals are accordingly allowed. So,
what is the page, paragraph 20 of the judge Guru Das?
Yes, Lordship. Next, kindly come to page number 19, Lordship. That is the MAT 119, Lordship. MAT 842 of 2022. That is the Guru Das judgment, Lordship.
Paragraph 20.
Page number 131. No, 134. Paragraph number 20, starting from page number 130.
Yes.
The court writes the judgment neither for its intellectual satisfaction nor for intellectual consumption by others. It writes the judgment for common people, but generally a judgment delivered by a court is bound to be riddled with legalism beyond comprehension of common man. As the issue decided here touches the interest of common people, we deem it proper to summarize our findings as follows. Compassionate engagement as a dealer can be claimed on two events: death of the dealer or incapacitation of the dealer on medical ground. The incapacitation of the dealer on medical ground is subject to satisfaction of the competent authority. When a dealer is incapacitated and he has expressed his desire opting for any of his legal heir to look after him and his business, then such legal heir so opted should file an application in Form C contained in 2013 control order along with necessary medical papers touching on the nature of incapacitation of the dealer and requisite affidavit or option exercised by the dealer. In the event of death application in Form 3 of 2013, control order along with Annexure 1 and requisite fee should be filed. And such application should be accompanied with a requisite no objection affidavit from all dependent family members and death certificate of the ex-dealer. If more than one family member are dependents on the deceased dealer, they may submit joint application in accordance with this scheme. In the event any application filed during the lifetime of the dealer exercising the option in favor of the applicant shall be entertained if the dealer dies before any action is taken on the application within the time limit specified supra by us, but hereby the application so filed does not stand rejected. On filing of death certificate of the ex-dealer by the applicant who had applied during the lifetime of the dealer, the consideration by the authority shall. In case of permanent incapacitation, the authority concerned may satisfy themselves on the basis of medical certificate and medical papers filed, or they may conduct any inquiry according to their discretion if they do not get satisfied on the basis of medical certificate and medical papers filed. In case of death, any of the legal heirs may file an application in Form C along with Annexure 1 thereto, accompanied by requisite fees and death certificate of the ex-dealer. He should also file such no objection affidavit from other dependent family members, and he should supply the names and address of the family members who has or have not filed no objection affidavit, so that the competent authority may issue notice to them for an inquiry to find out as to whether were dependent on the deceased on the date of his death. I am pausing here again, Lordship. Inquiry to find out as to whether were dependent on the deceased on the date of his death. If on sufficiency of notice issued by the authority, the legal heirs who has or have not given no objection affidavits does not turn up, it would be presumed by the competent authority that he or they have no interest in the matter. The SDFC should not conduct roving inquiry to find out the factum of dependence. It should be an administrative inquiry giving opportunity to interested family members to prove his or her case that he or she was dependent on the deceased on the date of his or her death. If all the family members have filed no objection affidavit, no such inquiry is necessary. If one or more than one of the family members have not filed no objection affidavit, such inquiry may be conducted in respect of their claim only. So, Lordship, as per section 20, Lordship, as per paragraph number 20, according to paragraph number 20, the inquiry has been held. And the inquiry has been held, the field inquiry has been held, the panchayat report has been collected, and thereafter the revision order has been passed on 20. Now I'm coming to the reason. Page number 14 of my affidavit of reason order in compliance of the order passed by Honorable Justice of Calcutta High Court and in connection with FMA 106 but the state of West Bengal and others with FMA 106 the stated 3rd January 2020. Whereas the Sodish Chandra Das of village such and such, block such and such, license number such and such, expired on 18th March 27. Whereas after this device, one of the legal heirs, Sri Chandra Das, filed an application for grant of license of operational grounds on 21st April 2017. With application in form of PR channel, but Sri Chandra Das could not provide NOC of other legal heirs of Sodish Chandra Das, ex-MR dealer, after several reminders from the SDFC government. Whereas it appears that Sodish Chandra Das during his lifetime made an application for transfer. Whereas it appears Sodish Chandra Das, that is the deceased, during his lifetime made an application for transfer of his dealership in favor of Ajit Kumar Das on 2nd March 2016, along with the application by Ajit Kumar Das in Form C and PR Challan amounting to 1,000. On this account, an inquiry in respect of the state application was made by the area inspector, and an inquiry report the status of Ajit Kumar Das uninquired. However, before consideration of the state application, Satish Chandra Das was expired. As per the observation, the Honorable High Court in the judgment passed in case matter MAT 842/2022, Das versus State of West Bengal in para 25, Roman 5, the state application of Ajit Das does not stand rejected. Lordship, I am again coming, Lordship, to para number 5, Lordship, of Guru Das for my satisfaction, Lordship.
Para number 5 or 20?
Paragraph 20, subpara 5 of the judgment Guru Das. Page 136, Lordship, of the petition, writ petition. I am placing both the things side by side. And this is the third, 1, 2, 3, third last line. This is the legal order passed by the sub-divisional officer that as per the observation of the Honorable High Court in the judgment passed in case matter MAT 842/2022, Das versus State of West Bengal in para 20, Roman 5, the state application of Ajit Das does not stand rejected. Now I am coming to the para 5, Lordship, of Roman 5, para 20. In no event, any application filed during the lifetime of the dealer exercising option in favor of the applicant shall be entertained if the dealer dies before any action is taken on the application within the time limit specified supra by us, but thereby the application so filed does not stand rejected. On filing of death certificate of the ex-dealer by the applicant who has expired during the lifetime of the dealer, the consideration by the authority such. Now, Lordship, I am coming. So, as per this paragraph, the reasoned order has been taken into account. Next paragraph. Whereas, as per the direction of the Honorable High Court, to dispose the matter, considering the application of both the applicants, a hearing was conducted by the SCFC Hadra with both the applicants, Ajit Kumar Das and Shri Shankar Das, by memo number such and such, at the chamber of the SCFC Hadra. Whereas in the scheduled hearing, both of the applicants appeared and stated that they want to contest of the dealership on compassionate grounds. None of them could produce NOC of all the legal heirs of their father, Sri Satish Chandra Das, ex-dealer of Rani. And whereas Sri Ajit Das states that none of the other legal heirs except him were dependent on the deceased dealer Satish Chandra Das at the time of his death, and hence question of NOC from other legal heirs does not arise. He also produced affidavit of his father when applied for license on the ground of incapacitation, mentioning that all other sons, Sri Satish Chandra Das, have been separated, and the daughter married and living with her husband, and only his son Ajit Kumar Das dependent on him as he is unemployed and in. Whereas Sri Shankar Das during hearing could not produce NOC of Sri Ajit Kumar Das, it is very much natural. His brother and Srimati, whereas Sri Shankar Das during the hearing could not produce NOC of Sri Ajit Kumar Das and his brother, and Srimati Mohammed Das, her sister. This NOC was not offered. He stated that his brother Ajit Kumar Das instead applied for license and could not have been NOC. Sister Mohammed Das in other states owing to his marriage, thus NOC could not be corrected. He also admitted that he had negotiated a license in state at the time of death of his father, and whereas hearing was also called upon SCFC Hadra, other legal heirs of the deceased dealer Satish Chandra Das, namely Balos Chandra Das, Tarapad Das, and Mohammed Das, by memo number such and such, regarding their NOC and dependency on their deceased father, led Satish Chandra Das, Ranibad at the time of his death. Whereas Madhu Chandra Das was appeared for hearing on 5th April 2023, he accepted the providing NOC to Sri Shankar Das. One of the applicants, Madhu Chandra Das, admitted that he was an escaped bulk officer, holding license number such at the time of death of deceased father Sri Satish Chandra Das and not dependent. Whereas hearing is also talked to Tarapad Das by memo number is, but he failed to access the hearing. He replied via email that he is insured and is unable to attend the hearing. Further hearing dates were also allotted to give 5 million of the and such dated this, but he could not attend any of the hearings. I think the same law. Besides, he stated in his reply via email that any suitable brother may be decided upon that he has no concern on this matter. And whereas Srimati Mamata Mita called for hearing by memo number and suggested, but she did not appear an inquiry. After the inquiry conducted by the undersigned and directed by the Honorable High Court to find out the dependency of the legal heirs of the deceased, Emma Dita Satish Chandra Das at the time of his death, following further observation. Since Sri Badhu Chandra Das was an LK oil bulk dealer holding license number at the time of this deceased father Satish Chandra Das, he was at the time of this Satish Chandra Das, he had means of subsistence and was not wholly dependent on the deceased father Satish Chandra Das. At the time of his death, requirement of entry from him does not arise. Next best option. Srimati Mamata Mita did not appear for him. She did not appear for his earlier some hearing board. After the inquiry,
You start reading from paragraph 4.
Of the two applicants, Sri Shiv Chandra Das was holding LK oil retailer license hearing number such and such, which suggests that he was employed and that means of subsistence was not fully dependent on his deceased father, late Satish Chandra Das, at the time of his death. Thus, concluding Sri Ajit Kumar Das does not require anything from him for license on compassionate ground. After inquiry, it is found that Ajit Kumar Das was helping his father, Sri Satish Chandra Das, in running FPS up to his time of death and was not helpful. He was dependent on his area inspector during his inquiry at the time of application on incapacitation by Sri Ajit Das also found him unemployed, and an affidavit by his father, Sri Satish Chandra Das, was also submitted, stating that he, Ajit Das, was unemployed and was helping him running his FPS. Local Chief Pradhan also confirms that he was helping his father in running FPS and was living with him and was dependent on him. As per clause 20C of WBPS Control Order Preponing 2013, while applying, the applicant shall have to furnish no objection from others and but in the form of an affidavit included for consultants. Family members, as mentioned in clause 8 of clause 2 of WBPS Control Order and Preponing 6 family member with spouse, dependent parents, dependent sons and daughters, for the purpose of considering engagement as dealer, distributor, or compassionate ground. Besides, it is mentioned in clause 20, the paragraph of Control Order that prayer of any of their family members of the deceased incapacitated dealer having no regular subsistence will be considered compassionate ground, provided such prayer along with formal application form in this context. This is to note that Sri Shiv Chandra Das was already holding a separate SK oil license at the time of death of his father, and also at the time of application for FPS license on compassionate ground, thus having means of subsistence and not wholly dependent on his father, Sri Satish Chandra Das, at the time of his death. Besides, he failed to secure energy on dependent earlier that his father also not Das. After he had ample opportunity by the SCFC Khatra. Hence, the application Shiv Chandra Das cannot be recommended for license on compassionate ground. Based on all these facts, it is evident that Ajit Kumar Das, son of his dealer, late Satish Chandra Das, does not require NOC of any of the legal heirs of late Satish Chandra Das, as all of them were having means of subsistence or living separately and not wholly dependent on their father, Sri Satish Chandra Das, at the time of death. Hence, application of Ajit Kumar Das is So, Lordship, as per paragraph number 20 of the judgment of Guru Chandra Das, and as per the order of us by Honorable Justice Chief Procedural Justice, that inquiry was being held and it had to be found that at the time of death of the deceased father, who are dependent and on the field inquiry and perusal of document, and as considering the paragraph number 20 as per the direction of the Honorable Court, the reason order is being passed by the subdivisional control officer on 29 May 2023.
And what is the view of subdivisional controller? That Ajit Kumar Das is eligible. Whether Ajit Kumar Das filed the requisite fees within time?
After 60.
Why?
That was already been decided in the previous
Where it is decided?
because on the
Show me whether he has particularly complied with all the norms. As you have stated in your affidavit in opposition, that the candidature of Ajit Kumar was cancelled due to non-filing of requisite fees.
yes, that is the paragraph number page number 3 also. The case application of Ajit Kumar Das could not be considered because application fee was deposited after 60 days period.
Yes.
This has happened previously. Previously means before the all litigations, when they have applied before the controller. The controller has
Whether that was condoned by any order of the court? That this fee filed after 60 days is condoned and accepted.
this hearing has to be taken, this has order been passed.
Yes, that's why you have passed the order. That is the subdivision controller has allowed the Ajit Kumar Das. Whether this matter was taken to be considered. Whether you have considered this matter, the subdivision controller.
Order challenge before the lordship, and thereafter there was a proceeding of the state.
Yes, go to the order.
Lordship, the last order.
No. Go to the order by which the subdivision controller has passed the region order.
That is of the
By the order of division bench.
that is it's number starting from page number 120.
Page number 111, 113.
So I'm coming to order passed in FMA.
Page 116 of the writ petition. Paragraph 9.
From the facts narrated, it is clear that two brothers have filed applications for appointment as fair price of dealer on compassionate ground. Appointment on compassionate ground can be given to one if said is found.
Yes, if the said one is found to be eligible in all. Yes.
Requirement of filing no objection certificate is concerned, it has been held.
That is a separate issue. You have conducted the hearing and passed the order.
Lordship, as it has been stated that that has to be followed the rules of judgment passing Guru Podutas. So on the basis of that, Guru Podutas, this inquiry has been held and it has been found that Ajit Kumar Das is eligible. And paragraph number 5 of the judgment of Guru Podutas, where the already already any application has been made at the time of death, such cannot be rejected. That number of Guru Podutas, paragraph number 25, Lordship. Paragraph 20, Roman 5, Lordship.
Yes, read the paragraph.
Lordship.
It has been stated that the application or no objection filed by the earlier FPS dealer cannot be taken into consideration.
Lordship, kindly come to page 136, Lordship, paragraph number Roman 5, Lordship. That is a Guru Podutas judgment. On the event of that, such reason order is passed. In no event, any application filed during the lifetime of the dealer exercising option in favor of the applicant shall be entertained if the dealer dies before any action is taken on the application.
Yes.
The time limit specified by
That means you cannot argue on that matter.
But there are that
Regarding earlier no objection, earlier affidavit, that became infructuous. Why this matter was mentioned time and again by the region order, in the region order?
order has been passed on the basis of the field inquiry, and it has been found that who was the eligible, who was dependent.
So why Ajit Kumar Das made eligible when he has filed the application without any fees?
Lordship, thereafter, Lordship, kindly comes to the last portion, Lordship. This is only found eligible. Now we have to given a fresh thing has been occurred. This has been occurred.
No. Why fresh thing happen?
In application of Ajit Kumar Das is found eligible.
Yes, how it is for he is found eligible.
Further,
Further processing means
he have to file the TR challan again in a fresh form.
how can you allow him? How can you allow him beyond law? How can you? What is the provision that you can file him? Allow him after filing of the application with beyond the time.
Lordship, the reason order passed just on the basis of the field requirement.
No, you have passed the reason order and found that the Ajit Kumar Das is eligible. I am just asking you question: how Ajit Kumar Das eligible when he filed the application without the proper requisite fees? Can you allow him to file the requisite fees, or you allow him without requisite fees? You can apply for. You can go for. No, I am asking you. Just explain me. What is your stand? What is the stand of subdivision controller?
Present stand is Lordship, page number 8, Lordship, paragraph number 6 of my affidavit, Lordship.
Page number.
Page number 8, paragraph number 6
Page number 8.
of my affidavit. This is the present stand of the controller. Lordship,
Yes.
I submit that the facts and circumstances to present affidavit in opposition. I further say that several opportunities have been given to both the applicant HON'BLE and Kumar Das by the same, but they failed to come to a settlement regarding no objection certificate at every instance. Both of them filed several writ applications in the Honorable High Court. At Calcutta, and at each instance, the Honorable High Court disposed the case, instructing the licensing authority to provide them opportunity to submit NOC of all legal error, but they failed to do the same every time. In connection with WPA 14809 of 2023, this petition, the decision of Honorable High Court regarding selection of a suitable candidate among the applicants will be complied by the respondent. Hence, I pray the necessary order from the Honorable. So, presently, who will be the eligible candidates found by the Honorable Court?
No. That is not the issue here. Issue of the writ petition is the reasoned order. So you are here to justify the reasoned order. I have only one question: that whether the Ajit Kumar Das made eligible without filing requisite fees.
The reason order has been passed on the basis of the judgment passed by.
I understand. The subdivisional officer has passed the order, reasoned order, making the specific direction that the Ajit appears to be eligible. How Ajit appears eligible without filing requisite fees? Why that has not been taken into consideration?
Whether Ajit filed an fee data or not, that is I have not.
No, that is you are clear. You are clear in your affidavit in opposition.
Yes, that is
You
right.
cannot beyond by
I cannot
that the Ajit, yes. Ajit has not filed. But beyond statutory period. No order is there on any respect like that. Yes, I shall hear it. No issue.
On page 128, my lord, that is there, my lord, a 60 days period, my lord. Page 128 of the Gurupada Das judgment, man. Kindly considers that. Paragraph 11.
Very well, I will hear you. No issue. Let him answer. Let her answer first.
Right.
Okay, that was not taken into consideration.
Lordship, please, Lordship, kindly come to. This is the page number starting from page number. This is the order. This is the order. This order is very much illegible, Lordship. Lordship, page number 68, 69.
68, 69 of what? 68, 69. What is this?
Lordship, this is about
This
the
is-
TR challan.
No.
Lordship,
Who
page
passed the
number
order?
69, Lordship, what, Lordship?
No.
Petition page number 69, Lordship.
I understand 16. What is the order?
Yes, Lordship.
This is the order of?
This is the order of the subdivisional officer controller. Previously, before the read petitions and all. This was the appellate authority. Lordship. This is the order
Appellate
passed and thereafter the read petitions and all.
Subdivision controller is the appellate authority.
The past order, not appellate authority.
Okay.
I'm pardoning, Lordship. The past order passed by the subdivisional controller.
Against which the appeal has been preferred.
Yes, yes.
Against which the appeal has been preferred.
Lordship, this is the order, Lordship. Lordship, kindly come, Lordship.
Order in respect of the application of whom?
Order in respect of application of Shiv Shankar Das.
Shiv Shankar Das. That is the present petitioner.
Present petitioner here. Lordship, here, Lordship. This application was not understand 60 days in timeline, neither the same rules with Anderson and neither the fees to Bachelor and attacks was further mention here that the form C is not enclosed in the application and no date of signature on it is not submitted. Since the date of the deceased dealer was on 18th week 2017, but the amount for TR Chalan as application fee was submitted to Treasury attached bank UPI such and such, which proves that the TR Chalan was not attached during the time of application as claimed by Sri Ajit Kumar Das. Later, he has for through the TR Chalan dated 29 May 2017, he has filed the TR Chalan through UBI bank. This one thing we got at the.
You have taken the matter in your affidavit in opposition also.
In the affidavit.
Same.
In the affidavit in opposition, we have taken that this was not deposited at the proper time.
Yes.
Within 60 days, and such has also been reflected here.
That is the you have taken in the affidavit also.
Beyond the
Yes.
But the such has been deposited, but later. That is the after 60 days, and which is not coming within the provision. Therefore, the first time it was been could not be considered. But after all the litigations and all, and after the order of the Honorable Court, and on the basis of the Guru Pada Das judgment, their thing was only mentioned because in all the latter orders, there's no question of the Chalan was came up.
No.
Only
The issue is that you have turned down Ajit Kumar Das initially on the said ground that your Chalan is not filed. So he preferred, no, I am not taking over, just take it one after another. You have turned down the prayer of Ajit Kumar Das on the ground that you have filed application not with the Chalan.
Not with the Chalan, not with NOC.
Not with NOC. So the matter, he preferred the writ petition. Thereafter, one direction was given. Thereafter, appeal. Both the appeal come up with the Ajit and the Shiv Shankar. Joint direction was made in the appeal to dispose of the both applications by a conjoint hearing in terms of Guru Pada regarding no objection. Okay.
Yeah.
But the order is there that you have to pass a rigid order and pass the license in favor of the any of the parties if they found eligible. This is the term.
Yes, Lordship.
How he found eligible Ajit Das?
Eligible at the time of death of the deceased father. This was the order, Lordship. And as per the order.
I understand. No. I understand what you want to submit. Just answer me my question. That matter has not been taken into consideration by any of the parties and by you also. Very well. This is another question. And now, what is your argument about the argument advanced by the petitioner?
Lordship, I am concluding, Lordship. I am pointing out two things, Lordship. First of all, the field report, the inquiry report, the recent order passed on the basis of the order passed by the Honorable Appellate Court, and on the basis the dependency at the time of death of the deceased father. This and NOC. On regard of these two issues, the inquiry has been made. Number one issue, the NOC, who will give, why give.
I understand your submission. I understand your submission. You don't have to argue further. I have just want you to, I just asking you What is your argument regarding the argument advanced by the petitioner?
Lordship, I cannot go beyond my affidavit, Lordship. In my affidavit, is clearly stated that.
I have gone through your affidavit. No, I just want your answer. What is your argument regarding the argument advanced by the petitioner? You have to argue.
Lordship,
Regarding, I am mentioning you the points.
Yes.
Point is that he has specifically argued that Shiv Shankar Das, that is the petitioner, Shiv Shankar Das had a recent dealership, kerosene oil. Okay, at the time. No. Shiv Shankar. He argued, petitioner argued that at the time of inquiry, he has stated that his kerosene dealership was not profitable. This is the argument. This is the argument in the read. I know the entire, but he specifically argued it was not the profitable, so he has left the license. Whether that was taken into consideration, but why not? It was not considered. What is your argument?
Lordship, the legal order or the inquiry report, whatever it has been given, that is as per the order of the honorable court. And as per the honorable court, it has been stated that who are the defendant at the time of death of the father. So at the time of death of the father, it was found that Shiv Shankar Das has the licensed oil.
License of kerosene oil.
On the basis of that, but never it has come to the order of the honorable High Court or other thing that whether after effect what is that been taken. But it has to be considered and it has to be felt when inquiry has to be made that at the time of death of the father, who are the dependent and what is their status and what is their status. So on the basis of that, it has been found as the oil bill, whereas and other legal heirs have also have their own professional income and are not dependent on the father, Satish Chandra Das, but Adit Kumar Das was dependent. So this conclusion has came out. So on the
So your argument is at the time of demise of the previous FPS dealer, the Shiv Shankar Das had a SK dealer license. That's why his candidature was not considered.
So we are considered at the time of death who are the dependent on the father. So as per basis of the order passed by the honorable.
So why the Ajit Kumar Das appears to be dependent?
This upon the field inquiry report it has come to the conclusion that Ajit Kumar Das was dependent. Lordship kindly come to the field inquiry once again, Lordship. This is the report of the field inquiry and the report of the Pradhan.
Yes, what Pradhan said?
At the lifetime of his father, he was actually his father and he was totally dependent upon his father.
Yes. He was fully dependent upon his father. But
Yes.
whether it was not stated like that. It was stated that his father was dependent upon. Yes, read it. His father was dependent upon. Yes, read it. I have read out.
বর্তমানে যিনি 2017 তারিখে মৃত্যুবরণ করেন তিনি এফপিএস ডিলার ছিলেন এই রেশন দোকানের সহযোগী হিসাবে এফপিএস ডিলার ছিলেন তার রেশন দোকানের সহযোগী হিসাবে দীর্ঘদিন এমনকি তাহার কুমার দাস সমস্ত কর্ম সম্পাদন করিয়াছেন তাহার দোকানিতে অন্যান্য পেশায় নিযুক্ত আছে তাহার সবাই পৃথক পরিবারে বসবাস করেন। কৃষক সতীশ চন্দ্র দাস 1900 অজিত কুমার দাসের ঈশ্বর সতীশচন্দ্র দাস পরিশুদ্ধ অজিত কুমার দাসের পরিবারে থাকতেন। সতীশচন্দ্র দাস পুত্র অজিত কুমার দাসের উপর বিস্তারিত পর্যন্ত
Yes. Then the FPS here was dependent upon Ajit.
Yes, because he was medically not fit and Ajit Kumar Das.
So how can you came to the conclusion vice versa?
Meaning of the coming lordship that Satish Chandra Das was not sound. He was not medically fit, and therefore his every walk of the dealership.
No, it was not taken in this inquiry report. It was not taken in the interest report. In the resin order, you have not stated like anything that he was mentally ill like that or physically ill and he was running his business.
But that is not the thing because he was not mentally challenged or physically challenged.
Then
Illness he could not able to do it, and that is why Ajit Kumar Das used to help him, and therefore he has filed one application for transfer in the name of Ajit Kumar Das.
no, you cannot take out this application now. You are debarred. But you have already taken this point.
But he has shown his willingness. He has shown his
No, his willingness is no more now. Now it is infructuous. You cannot argue on that basis.
But is that your lordship, the honorable court order directed the controller to have an inquiry at the time of the death of the deceased one, but not afterwards. What is the situation afterwards? Who is
No, I understand. At the time of passing resin order, the authority concerned must have taken the stand as per your argument that Ajit was helping his father. And Ajit, his father was totally dependent. Ajit was totally dependent.
My lord, if your lordship kindly sees what my learned friend is relying on Pradhan Huludkarni Gram Panchayat, my lord, I have filed a supplementary affidavit wherein, my lord, it has been.
No, I understand. I have heard. You don't have to argue now. I know.
lordship kindly come to page number 10 once lordship of my affidavit in opposition. Page number 10 of my affidavit in opposition.
Yes.
Paragraph number 3 lordship. Ajit Kumar Das, Shiv Shankar Das, both were asked to produce of their financial stability document related to he informs that the business was run by his father. When he was alive, he had produced trade license and GP tax copy during the inspection of the inquiry officer. Paragraph 3 and paragraph number 9 and 10 lordship. While asking about if any family member of his family is in government service, Ajit Kumar Das informed that he was not involved in the government.
Regarding his wife.
Yes, then his wife is in care. And on asking that he has any other dispute for his family name, Ajit Kumar Das informed that he did not have any dispute of his name at the time of death of his father and currently has only groceries of his husband. So he has depending on at the time of death of his father. So at the time of death of his father, he was dependent. This order has only been passed by the honorable court that to find out who are dependent at the time of death of his father and why NOC is required or not. So on this failed inquiry on the report of the Gram Panchayat, the reason order has been passed that at the time of death of his father, Ajit Kumar Das was dependent on his father as his father and the son Ajit Kumar Das resides together and everything Ajit Kumar Das used to do for his father, and so the conclusion has been came.
No, you are arguing. It is not in your report or otherwise that they are staying jointly. That is not in the report or in the field inquiry report. It was not in there.
Dependent. I'm only placing the word dependent. Was nothing else. So this is the conclusion came.
Okay.
So now I am totally leaving upon your lordship. Whoever will be found eligible, the controller is there to provide the license to him. But on the question of TR channel, which has been fallen from your lordship, that this TR channel issue was never been raised before the appellate court before the Honorable High Court, but the only issues regarding dependency was raised and NOC was raised, and on the basis of that, it is an order has been passed. So now the present condition, I cannot go beyond my present affidavit. So in the present affidavit, it's already been mentioned that the Odit Das could not file the PR challan within proper time. Though they have filed the challan, but after that time. As this issue has never been raised, so this issue has not been answered in the written order.
Yes, it was raised. You have filed the specific objection. Affidavit in objection, you have stated his candidature as cancelled on that ground. Only on that ground. That was up to the appeal court. That was there. In the appellate forum, that was not considered. So, but it was stand. That means it was stand. It was not denied, not passed any order on that point. So your view and your order in respect of rejection of Ajit Kumar Das regarding non-filing of the TR challan, it stand at till today. Till today, it was not condoned by any of the court.
But as the several orders passed and the order passed by the
Very,
appellate
very okay.
As the Justice Sina's order was also there to take into consideration and to fresh report, give a fresh, not just the lordship kindly come to that point. To take fresh hearing, lordship.
Very.
Take a fresh.
Okay, I understand.
Their lordship that on the basis the recent order which has been passed, that is on basis of the inquiry and on the basis on the order passed by the appellate courts.
Very.
Now I am praying with lordship, whoever your lordship is found eligible, we are entitled to give the license because the people, local people are facing trouble. They have to go a few distances for getting their rations. So if whoever will be eligible, otherwise lordship, I am just placing as per the rule. If nobody is found eligible, what to do?
I understand what to do. No. Press notification.
Notification be invited and the eligible candidates will be given dealership in that.
Very well.
I'm ready.
Yes. For private respondent.
Private respondent. Oh, yes.
Contesting private respondent.
Eight, 9, 10.
Okay, let me hear you then.
Well,
you are in the party in this matter?
Yes.
You are respondent number?
8, 9, and 10.
Respondent. Badol Chandra Das, Tara Podo Das,
and Mamata Mohitas.
You yourself, and Mamata Mohitas. Other legal heirs.
Other legal heirs.
Except the present petitioner and the contesting respondent. Very well.
So for this matter, my lord, I am personally known about these facts and circumstances of the case. Whereas my father had died in 18 March 2017. Now it has been decided by the second brother of Shiv Shankar Das, the present petitioner, filed applications for grant of license. Now, according to these applications, along with the all requisites, forms and other prescribed forms under the Act has already been complied. Only in respect of the no objections from the others. This is the dispute was arises from the petitioner. Now, the private respondent 7, that is Ajit Kumar Das, did not give any no objections only to that effect that he has taken entire property, whereas we are living and within the dependent upon our father, then there is no any allocations of the property or the business has already been taken over by the respondent number 7, that is Ajit Kumar Das. It has not been corroborated appear in the inquiry report or any other report or any other order that he has taken the business, everything, including the MRD.
No, during the inquiry, have you stated this to the inquiring officer that your business and all properties has been amicably settled?
So for the 2 times has been inquiry was held.
other respondents, they have not participated.
Yes, I know. But so far this much the inquiry report is concerned, the first inquiry report, when the inquiry was held only in respect of the Shiv Shankar Das. Now inquiry report was submitted. Ultimately, they have taken only to the Shiv Shankar Das to produce the no objection certificate from the others. Now, during this pendency of this application of Shiv Shankar Das, there is no questions of any Ajit Kumar Das has already been challenged or any contested. Now, ultimately, a series of notices has been served by the SCFS to the Shiv Shankar Das writ petitioner to submit no objection. Well, there is in a fact in regard to this no objection that in between the legal heirs and successors of the others, they are also proposed and to the Shiv Shankar Das to make an application. Now he has continued duly applied. Now only in absence of the no objection certificate, he has not been considered. His application has not been considered.
Yes.
Then ultimately, the respondent number 7 has taken a ground that when my father was alive, that this license has to be transferred to this person. Whereas the applications has only been given by my father that he is only one son. It has been suppressed to the other sons and daughters. That is when our fathers was living. Then hearing was took place at 2 p.m. by the office of the respondent number 6. Now on that day, I was practicing in the Calcutta High Court. We have been informed from the other legal heir successor that immediately the license will be transferred. Then I made an application through an email that he is not only the legal heir successors, but also we are the legal heirs and successors of that father. Now, ultimately, that hearing was not.
At that time, Sotiswa chala.
Yes. The hearing was not, could not be done, but hearing was stopped. No order was passed. Ultimately, the case of Ajit Kumar Das was pending. Now, ultimately, the application, when the applications, no objections was not found, not submitted by the Shiv Shankar Das, then they have taken that, yes, it should be rejected. Only on the ground. Then after having rejection, the hearing was took place pursuant to the court's order of my Lord Justice B. Sinha. Then ultimately we have already appeared all the parties in absence of the daughters because he is living in the outside. Ultimately, an order was passed. That order was challenged before the appellate authority, before the district controller. District controller appealed the order. Ultimately, the order was passed in regard to this matter before my Lord Justice Amrita Sinha. Now, my Lord Justice Amrita Sinha was given liberty to us that within 90 days to be settled in between the brothers. Because one application, another application, both the application is to be concurrently taken by the authority. Whereas the earlier applications or earlier proceedings when our father was alive, that was not found any record in the office. We are also challenging that there is no any TR challenge form or any license fee or any other thing. Even no hearing was concluded by the authority. But ultimately, subsequently, an order was passed in regard to this non-submission of the no objection. Then the questions of this, the present proceedings, that the entire property has taken by Ajit Kumar Das. Now, Ajit Kumar Das has leading business, agricultural property, other grocery shops, including the other property, vehicles and other things, even not only this our property, but also the other property was there. That is also a grocery shop. He is running his own name and own business as it appears in the record. But we are objecting that whatever it may be, only the MR dealerships we have not been objected. But so far these applications ought to have made after having death. But that was not done within the 60 days. Now, after that, my lord, the authority has been passed this order in absence of the other property or any within the vicinity. Only questions is the dependent and independent. Now, independent or dependent, that was considered by the authority and eligible has been declared in respect of the Ajit Kumar Das. So, I am putting this question that where it has been eligible and what ground he has the eligibility.
Eligibility ground is this, that he has made an applications within the certain period according to the rules and regulations. Even that it has not been found after that, according to my learned friend submission, that it has been later on, but it could not be considered. Therefore, my lord, I am also, my lord, during the hearing, during the hearing of the last, my lord, the region order was passed by the authority. When I was, my lord, on accidents, my lord, I was injured, my lord, at Calcutta. Now, one email I was submitted to the authority that any competent persons is to be considered, that will be considered. We have no objection. So far, my information is concerned. Now, ultimately, this order has been passed only on the subject that no objection is not required because he is dependable. One, the submissions of the concerned panchayat, that is also directed that he is dependent on his father, not others. Whereas we are family settlement has already been as it is. It has not been divided.
Regarding family settlement, nothing has been filed in this writ petition.
No,
You have not stated or you have not filed any document.
No, other
You
legal
have
errors has
also
been
not
submitted.
No,
That
you
was
have not filed any document before the authority concerned also.
No,
At the time of inquiry.
No. Time of inquiry prior to that, at the time of hearing, we have other brothers has already been submitted to the hearing. All records. That was not appeared in the inquiry report or any other order. It has not been. It has been submitted. All these things that was not considered, or it has not been appeared. No, ultimately, yesterday, my learned senior friend has already been submitted regarding this.
Yes,
all these
submitted
things.
that there
all
are
these
some
things.
family
So-
settlement is
So,
there.
the Sipsong
There is nothing in this entire paper regarding your family settlement, and you have not stated anything before the inquiry officer that it was our family settlement.
It has not been considered, even it has not been included in any of the report. We are submitting. We are submitting all these things, including the records.
No.
And also, admitted
the issue is that let me clear first. Issue is that the inquiry officer is only there regarding the notification, regarding the rule that no objection is required.
No objection.
Division bench said no objection is required from the dependent person. So you go and done an inquiry. Who is the dependent? Who is the dependent person? If they are dependent, then no objection is required. So the inquiry was conducted, and the inquiry officer said that the Ajit is eligible. Ajit is eligible. No other person was dependent. No legal heirs was dependent upon the income of Satish.
Yes.
That is the observation.
That is observed.
Ajit is eligible, found eligible. This is the final conclusion.
Yes. But he has not been unemployed. He has been everywhere. It has been taken. That's all the property and other business has already been running in his own name. As your Lordship found the yesterday record in regard to this. But so far, this the last region order has been passed by on the basis of the report. That report is also corroborated, and the impugned order was passed by the authority is also not in the face in the record. And we are submitting that the Lordship that Sipshankar Das is the eligible candidate, and also final applications within the time only in absence of the no objection. And so far, the dependence or independence that is immaterial. That is immaterial. So your Lordship will kindly pass this one.
Yes, for other respondent number 7.
When delivery দিতে সময় দেরি হয়ে যায়।
Very well, come on
8 July. 108
Pattern matter will appear on top. No issue.
Pattern.
Please take down argument on behalf of the respondent number 1 to 6. State respondent 1 to 6 concludes. The argument on behalf of private respondent number 8, 9, and 10 is also concluded.
এখন আছে দিস
Let the matter appear in the list on 8th of July 2024. On top as a pattern matter for the argument on behalf of respondent number 7. এটা দিয়ে দিন ওনাকে দিয়ে ম্যাডামকে দিয়ে
না না ইন্টারিম অর্ডার মানে if any interim order
Interim order is there.
interim order is there আচ্ছা আচ্ছা
এটা
my lord grateful man sorry.
But I am for the petitioner, my lord. I have almost concluded my submission.
Yes.
Just I shall sum up my submissions, and then I shall rely upon 3 judgments. Citation of those has already been intimated to both of my learned friends. My lord,
graduate.
just I am summing up my submissions. My lord. I have already concluded. The brief facts of the case is that on 26 September 2022, a vacancy for fair price has been notified at location Shurulia Gatepara, Beledanga, Mushidabad.
Yes.
Now, the copy of the vacancy notice I have annexed, but that is not so legible. So I have given a model copy annexing my writ petition, which will appear from page 34. There is a clause, my lord, the applicant must fulfill the following some conditions. Go down, shop room, details has been mentioned at page 35 of the writ petition. That is the vacant part of parcel of the vacancy notice.
Yes.
But clause 14 says at part 4, page 35 of the writ petition, that the applicant must submit following copies of original supply documents along with application. Well, this is very important. Well, 14 Roman 7a says the photocopy of the record of rights. Photocopy of the record of rights must be enclosed along with the application or uploaded along with the application. At page, my lord, 36.
Page 36.
My lord.
Documents
Next, I will also
regarding-
kindly see the B. B is very important.
Yes.
Document showing character of land as Dokan commercial Vastu if ROR is not produced. So, either record of right showing that the land is classified as Dokan commercial Vastu or any other documents. Along with the application, you have to submit, my lord.
Yes.
But clause 15.4 at part 5, page 36, denotes any suppression of facts, information, or incorporation, costumes of wrong information in the application form or attached documents will be considered as a good and justifiable reason for disqualification of the candidate or rejection of the application. So, 2 parts, my lord. Any suppression, concealing, misrepresentation, or any false document attached with the application leads to disqualification and rejection of the application.
Yes.
This is a mandatory provision. Now, my lord, I have applied on 14th of January 2023, which will appear from page 37. Details I have given. So far, my land record of right is concerned, that I have also annexed, which has been, my lord, classified as, my lord, Amon, your lordship, sorry, my lord, Dokan Ghor at page 37, it will appear on 8th of December 2021. Whether I have applied on 14 January 2022, much earlier. But private respondent applied on 1st of February 2023. This is very important. 1st February 2023. If you kindly see page 32, page 22 of the report submitted by the state, private respondent applied on 1st February 2023 at page 22 of the report. The inquiry report suggests that the private respondent submitted his application on 1st February 2023 at page 22 report.
Yes.
But land has been converted, so far my learned client is concerned, on 23rd of February 2023. 23rd February, application on 1st February. Record of right. It will appear from affidavit in opposition filed by the private respondent. They themselves has disclosed. So, but admittedly on the date of submission of application, land was not converted as per the prescription. It was recorded as amount. Admitted position.
Whether any other document filed?
Nothing. Nothing.
That,
there is no disclosure either in the state affidavit or in the affidavit filed by the respondents, private respondents. Admitted position. What, in addition to that, what they have done, my lord, they have enclosed the sale deed or the deed of gift, stating therein land has already been converted into Vastu from Amun.
From Amun to Vastu.
Amun to Vastu, sorry. Amun to Vastu. I have shown to your lordship that will appear from my lord.
Yes.
Your lordship kindly take up that. Just the affidavit in opposition filed by the private respondent. At page, my lord, kindly turn to page 18 of the opposition.
Yes.
It starts from page 18, my lord. Kindly turn to page 20.
House Bortomane VT.
My lord. But this has been affirmed on 30th June 2023, January.
Page 23.
My lord. It has been, my lord, affirmed, executed on 30th of June 2023, first page, page 18.
Yes.
It has been enclosed with the documents, along with the application. And if you also kindly turn to page 28, the major information.
Yes.
It says Aush. Why I am showing so? The clause indicates in the vacancy notice any suppression, misrepresentation, or false document. Admittedly, a document has been enclosed along with the prescribed application, saying that the land has already been converted, rather, my lord, classified as Vastu. On that day, admittedly, land was classified as out, which will appear from the same document as major information of the deed. So, my lord, first point, I have pleaded in my writ petition.
Yes.
That documents must be submitted along with the application. That criteria could not be filled in by the private respondent. That is to say, either record of right or any other document showing that the proposed godown and showroom is situated either in the Vastu land or Dokan.
Yes.
Second, suppression of material facts, concealing of material facts, rather misrepresentation.
Major information, it is house.
And
So
they have also annexed the
yes
documents
your
when,
submission
when it has been converted.
That is the misrepresentation.
My lord. And if you also kindly turn to page 32, they have admitted, they have also annexed ultimately the conversion certificate at page 32 of their opposition. Of the opposition. Conversion certificate. Application 22nd of February, and it has been ultimately converted on from house to VT on 23rd of February.
Yes.
So application was made subsequent to the submission of application. Placed before your lordship that the application was submitted on 1st February 2023 at page 22 of the report. in the inquiry report.
Yes.
So, my lord, there is no dispute so far these documents is concerned. My lord, another point, it has been disclosed by my learned friend appearing for the private respondent that priority preference who will get the preference if the marks are similar. A model prescription has been annexed in the opposition at page 37, dated 17th August 2021, in the opposition filed by the private respondent. It starts from page 37. If you want to kindly turn to page 39.
Yes.
Clause 7, district level fair price shop selection committee or the subcommittee, while giving its report, may take into following further consideration. A, in case of same total score, the applicant in the individual capacity will get the preference. None of us we are both are individuals, so that does not attract any of the preference. Then B, in case of two or more individuals with same similar credential qualify for a particular dealership, preference should be given to following: single woman, unmarried widow, separated with a court decree, so on. So none of we are following. 2, graduate unemployed.
Yes.
Admittedly, I am graduate. My learned friend client is a higher secondary pass, qualified. Then another preference, kindly see, my lord. C, if two or more applicant gets the same score, then youngest amongst them will get priority. Admittedly, my learned friend client is younger than me. He is younger. But I have submitted with your lordship from the report of the state.
So youngest among them will get the priority.
Priority. First preference, priority, same. If I graduate, I should be given priority. And if marks are same, even again them, then priority should be given to the younger.
Youngest.
That's pausing for a moment, man. I have shown from the report that both of us got 71 marks given by the subdivisional controller from the report. There is no dispute.
Yes.
I have also shown to your lordship from the report in the comments column, subdivision inquiring personnel written, I am the most suitable candidate amongst all.
Yes.
I have also shown from the report that all documents I have enclosed along with my application, including the documents of conversion certificate. So far, my learned friend's client's report is concerned, it says case may be recommended.
Yes.
There is no whisper that he or she is the most suitable. So, inquiring personnel on inquiry, field verification, taking inspection of shopcom go down, came to a conclusion, I am the most suitable candidate. However, marks have been given same. Now, entire file forwarded to the district level sub-selection committee.
Yes.
What is the duty of the district level sub-selection committee? There is no further inquiry, no further materials. Whatever materials considered by the subdivisional controller, that has been forwarded to the district controller, before the committee. First priority, my lord, kindly see clause 7, graduation. Then comes, my lord, age.
Just I missed the
report.
The notification. Geo 79.
Geo page, my lord, 37.
37
of the opposition. Page 39.
Yes, 39. Yes, got it. Yes.
My lord, kindly see, my lord, my case is that when the file has been placed before the district level selection committee, and they found that the both secured, my lord, 71 marks. And then that there is a remark, specific remarks, I am the most suitable candidate. And there is a clause of giving priority. Priority has been chronologically given. The first priority means, so far the qualification is concerned, graduation. The moment they give me priority, I will be the higher marks candidate. In that case, the second priority even does not come within the zone of consideration because I have selected 71 plus priority. There is no consideration of the same marks. So far, the second priority is concerned. If none of them gets any priority in the first column and got the same marks, then the question of giving second preference does arise. After giving me preference, there is no equality of the marks. I have been selected by top graduation.
So your submission is that in Geo 7A is to be considered first.
7B.
No, first A.
I'm getting to
Then B.
Then C.
B also mentioned that in descending order.
Yes.
That
Kindly read my letter first. District level fair price sub-selection committee of the subcommittee, while giving its report, may take into following further consideration.
Yes.
In case of same total, the applicant in the individual capacity will get the preference. Next, in case of two or more individual with similar condition qualifying for a particular preference would be given to following in the descending order.
Yes.
Then comes C.
Descending order means first B1, then B2.
My lord. Absolutely.
And thereafter C.
First A.
A.
If A does not, there is a difference between A, either my lord total score or so and so, then my lord B comes.
Yes.
In field. If the B fulfill the criteria or complete the selection process, there is no scope for taking advantage of C.
First B1, then B2.
B2, then C.
Thereafter C.
Thereafter C. This is my specific case.
Very good.
I'm thankful to my learned friend. My lord learned friend has annexed this document. He has the access. I don't have any access so far these papers and documents of the department is concerned. Somehow Mr. Singh has handed over possibly. He helped a lot to me so far this document is concerned.
Okay. So these are the two grounds.
My lord.
Okay.
Now only one paragraph I shall give from the report how my learned friend client got higher marks than me. Your Lordship, kindly take up their opposition. First, Your Lordship, kindly take how the marks has been given. That will appear from page 34. Kindly turn to my lord, page 31 of the report.
Yes.
But kindly see the serial number 1, Firoz Muqtadir Hossain, that is the petitioner before Your Lordship, my client. And last but one, Masadul Sheikh is the private respondent. Mr.
Yes.
Bandabata is representing. Kindly see after some columns 71.
Yes.
And Masadul also same 71. Now Your Lordship, kindly see the marks awarded by the district level selection committee. So far my client is concerned 22.
Yes.
So far my learned friend client is concerned 24. And just for a moment, kindly see the comments of the inquiring personnel. Just one paragraph I shall place before Your Lordship. First, Your Lordship, kindly turn to page 26. This is the penultimate paragraph of the report in favor submitted in favor of the private respondent. Kindly turn, my lord, 26. It starts from my lord 22. The name of the applicant 22 appear Masadul Sheikh, private respondent. Kindly turn, my lord, page 26. Last column. Overall comments with positive, negative recommendation. overall condition of the godown and cell counter is satisfactory. The applicant has complied all necessary government orders as per required. The applicant has submitted all necessary documents. But this is false statement. Neither record of right nor any documents showing dokan or bastu. Next. So considering all those aspects, this application may be recommended for issuance of new fair price shop license. Next. Now you have to kindly see the penultimate paragraph of my client. It starts from page 20 bottom. The report is from page 16. My client's name, Mohammad Firoz Sheikh, again serial number 9. Turn to page 20. Overall comments with positive, negative recommendations.
Yes.
The applicant has complied all the government orders as per required. As far as go down condition and location are concerned, it is most convenient in the beneficiaries of the projected service area. Considering all these aspects, the applicant is completely prepared in all segments and most suitable competent candidate amongst all. It does not differ the candidature. It is by, I'm raising a question. It has been placed before the district level selection committee. After that, what prompted them to give higher marks than my client to the private respondent? 24, 22, after these comments, everything is all right. Marks 71, 71. Enquiring personnel, ground level inspection. Recommendation may be done in favor of the private respondent. In all aspects, I am the best suitable amongst all candidates. I got 22, he got 24. Nepotism, favoritism, everything. It's a government largesse. No transparency. And what is the statement I shall show to your lordship? No, last. अभी तो तुम बोले बिना बोले आजके देखिए तो शेष कर
Whether there is any comment that why the marks was given.
My lord, that your lordship kindly term. Only one paragraph.
That he is the junior, that's why.
Yes, kindly turn to my lord, page 7 of the report. Page 6, 9, and 10.
Yes.
Paragraph 9, I am reading. It is stated that in the instant case, both petitioners and the respondent number 6 scored 71 out of 75 marks in the score-based inquiry system after the conclusion of the field inquiry. Thereafter, the candidature of all the candidates who participated against the said vacancy, including the candidature of the petitioner and the respondent number 6, was referred before the district level fair price shop selection committee for taking final decision. The district level fair price shop selection committee considered the candidature of all the candidates and awarded suitable marks out of total 25 marks to each candidate. The district level fair price shop selection committee, after giving an opportunity of hearing to the petitioner and the respondent number 6, including the petitioner and the respondent number 6 hearing, and after duly considered all other relevant factors for, that is, the area of the godown and the sales counter offered by the petitioner and the respondent number 6, awarded 22 marks to the petitioner and 24 marks to the respondent number 6. Thus, after completion of the marks awarded by the district level fair price shop selection committee and the marks awarded by the office of the answering respondent, after the field inquiry, the petitioner Firoz Mukhtar so 93 out of 100 and respondent number 5 scored 95 out of so. A copy of the final score. I stated that respondent 6 scored the maximum number of marks in the score-based inquiry system against the said vacancy, and thus the candidature of the respondent 6 was approved by the concerned. This is the statement. Not even the priority. They have not taken note of the priority. Where from they are getting?
They have stated that for the relevant factors, the area of go down, sales counter,
yes,
offered by the petitioner respondent number 6,
Yes.
awarded 22 marks to the petitioner and 22 marks for the
Yes.
respondent number 6.
Yes. Kindly come to my lord. Just since it is falling from your lordship, kindly turn my lord, page my lord 16. Everything is there. Marks has been allotted. Same marks.
Yes.
So far the go down is concerned. Shop room is concerned. Same marks. 10, 8, 8. Same marks. It's a clear case of nepotism and favoritism. I shall take another 5 minutes. May I conclude, my lord? So, all the judgments, subject to lordship. Or I can come back at 2 p.m. I can conclude within 5 to 7 minutes. Just subject to lordship consideration. Otherwise, another day.
Please continue.
Just now I can conclude.
Yes.
Within 10 minutes. So, my lord, I have made out a case of nepotism and favoritism. I have made out a case
Yes.
of unreasonable in the state action, unfairness, arbitrariness in granting government largesse license contract to a private individual. First judgment.
Yes.
But first judgment I am relying on, I have already handed over the citation to both of my learned friends. But it's considered the point that when the documents required to be submitted is the vital date. The Supreme Court says on the date of submission of application or maximum on the last date of submission of application, you have to submit your requisite qualification. In this case, the judgment reported in my lord 2013 volume 2 Supreme Court cases. 2013 volume 11 Supreme Court cases, page 58. Rakesh Kumar Sharma.
Judgments are not in the file because
No, I have not placed any judgment. I am handing over my.
Okay.
I have not. Sorry. Today, first day, I am placing. In this case, not yet, my lord. My lord, in this case, requirement was in regard to selection of service matter, B.Ed degree was required. On the date of submission of application, the person concerned participated in the examination, but result was not published. He stated in the application B.Ed qualified. This is the minimum qualification with graduation. Subsequently, he passed. And before interview, he qualified and submitted the documents.
Yes.
But the Supreme Court says on the date of submission of application, although you have participated, but result was not published. So you are not eligible. You have not qualified. You did not come, you have not come within the zone of consideration. You will kindly read paragraph, my lord, only one paragraph. Paragraph 12 first. 2 paragraph I shall read, paragraph 12. The brief facts have been stated.
Yes.
In UP Public Service Commission, this is what after considering the lot number. I'm reading paragraph 12. The court, after considering a large number of earlier judgments, all the judgment has been considered, then held that eligibility condition should be examined as on the last date of receipt of the application by the commission. That too was a case where the result of a candidate was declared subsequent to the last date of submission of application. This court held that as the result does not relate back to the date of examination and eligibility of the candidate is to be considered on the last date of submission of application. Therefore, a candidate whose result has not been declared up to the last date of submission of would not be eligible. Now, your lordship, kindly turn to paragraph 21. Let's summarize.
Yes.
In the instant case, the applicant did not possess the requiring qualification on the last date of submission of the application, though he applied representing that the purpose possessed the same, though he applied representing the person. The letter of order of appointment was issued to him, which was provisional and conditional subject to the verification of the educational qualification, that is eligibility criteria, character, verification, etc. Clause 11 of the letter of appointment dated 23rd of February 2009 made it clear that in case character is not certified or that did not possess the qualification, the service will be terminated. The legal proposition that emerged from the selected position of from the settled position of law as enumerated above is that the result of the examination does not relate back to the date of examination. A person would possess qualification only on the date of declaration of his result. Thus, in view of the above, no exception can be taken to the judgment of the High Court. It also needed, next paragraph, my lord, 22. It also needs to be noted that like the present appellant, there could be a large number of candidates. I'm pausing for a moment. The logic of the Supreme Court is that in our case, if we could just consider that there are other candidates whose land has not been converted. Since there is a condition, land should be either Dokan or Bastu, those people has not applied for. Like that, it is also needs to be noted that all the present applicants, there could be large number of candidates who were not eligible as per the requirement of rules advertisements, since they did not possess the required eligibility on the last date of submission of the application forms. Granting any benefit to the applicant would be violative of the doctrine of equality, a backbone of the fundamental rights under the Constitution. A large number of such candidates may not have applied, considering themselves to be ineligible, adhering to the statutory rules and the terms of the advertisement. There is no obligation on the court to protect an illegal appointment. The extraordinary power of the court should be used only in an appropriate case to advance the cause of justice and not to defect the rights of the others, create arbitrariness. Usurpation of a post of an ineligible candidate in any circumstances is impermissible. The process of verification and notice of termination in the instant case followed within a very short proximity of the appointment and was not delayed at all as to even remotely give a rise to a so and so. So there is no scope to give any advantage or legalize any illegal appointment.
Okay. Come on at two. Two.
Just to judge.
Yes. Continue.
But before this is I have relied on my 2013 volume 11 Supreme Court cases
Yes.
to show before your lordship the crucial date for acquiring the eligibility criteria.
Yes.
That is the last date of submission of application or the date when the person concerned submitted his application. And Supreme Court says whatever criteria has been notified, that should be acquired prior to last date of submission of application. On the same line, another judgment I am relying on, this is reported on 2017 volume 11 Supreme Court cases, page 521, one paragraph I shall rely on. 2017 volume 11 Supreme Court cases, page 521. Not just a short judgment, paragraph 6.
Yes.
I'm reading, my lord. The position is fairly well settled that when a set of eligibility qualifications are prescribed under the rules and an applicant who does not possess the prescribed qualification for the post at the time of submission of the application or by the cut-off date, if any, prescribed under the rules or stated in the advertisement, is not eligible to be considered for such post. It is relevant to note that in the rules or in the advertisement, no power was vested in any authority to make any relaxation relating to the prescribed qualification for the post. Therefore, the case of a candidate who did not come within the zone of consideration for the post could not be compared with candidate who possessed the prescribed qualification and was considered and appointed to the post. Therefore, the so-called confession made by the officer in the court that person having lower merit than the respondent have been appointed as SDI basic, having been based on a misconception, is wholly irrelevant. The learned single judge clearly erred in relying on such a statement for issuance of the direction for appointment of the respondent. The division bench was equally in error in confirming the judgment of the learned single judge. Thus, the judgment of the learned single judge as confirmed by the division bench unsustainable and has to be set aside. The Supreme Court came to a specific conclusion that a person fulfilled the eligibility criteria on the day and another person, even if the higher merits, if failed to fulfill one of the eligibility criteria even, will not come within the even zone of consideration.
Yes.
For our last judgment, I shall rely upon before lordship. It is reported 2012 volume 10 SCC. Page, my lord. Page 1, paragraph, only one paragraph, paragraph 10. Now, this is in relation to grant of state largesse contract agreement. What will be the role of the model state? The Supreme Court says there should not be any unreasonableness. There should not be any unfairness. There should not be any discrimination. There should not be any biasness. That entire selection process should be transparent to all. I'm handing over the copy of the judgment. If you lordship first come to the first flag of my, I have given 2 flags. If you lordship kindly take up the first flag. How many judgment has been considered? Kindly see. Chronologically given all the judgments. Kindly see, 98 judgment has been considered. And this is the first page, your lordship see. This is 5 judges bench judgment.
Yes.
5 judges bench judgment. And how many judgment has been considered? Kindly see, 94 judgment has been relied upon. All judgments, all over India. Then kindly turn to my lord. Next flap I have given, paragraph 107, only one paragraph. Paragraph 107. The second flap I have given. Have a lordship, I'm reading, my lord. From a scrutiny of the trend of decisions, it is clearly perceivable that the action of the state, whether it relates to distribution of largesse, grant of contracts, or allotment of land, is to be tested on the touchstone of Article 14 of the Constitution. A law may not be struck down for being arbitrary without the pointing out the constitutional infirmity, as McDonald case has said. Therefore, a state action has to be tested for constitutional infirmities qua Article 14 of the Constitution. The action has to be fair, reasonableness, non-discriminatory, transparent, non-capricious, unbiased, without favoritism or nepotism, in pursuit of promotion or healthy competition of equitable treatment. It should conform to the norms which are rational, informed with the reasons, and guided by public interest, etc. All these principles are inherent in the fundamental conception of Article 14. This is the mandate of Article 14 of the Constitution of India. Well, this is the judgment. So, my lord, I have made out a case, so far my writ is concerned, that inquiry has been conducted, marks has been allotted. With the remarks, I am a better candidate. File has been forwarded to the higher authority. Same marks we got. The higher authority given higher marks than me, and ultimately he has been selected. This is a clear case of bias. This is a clear case of discrimination. This is a clear case of unreasonable, unfairness, unjust, state bias, which is not sustainable in the eye of law. Well, these are my submissions.
Yes. Yes, for the state.
Okay.
এটা তো আরবান নাকি এটা Malad, before starting, Malad, there have been Malad, several amendments to the both the control orders. Malad, therefore, Malad, on my client has prepared a compilation incorporating all the amendments in the control orders for your lordship's convenience, Malad. We have already given 2 volumes to the division bench, Malad. Your lordships may keep this, Malad, without taking it to your lordships this file and may use it for the other matters also. Malad, না এটা তো তোমাকে দেবো কেন তো অ্যামেন্ডমেন্ট কি আছে
ডকুমেন্ট সব সময় সব লোক
দিস ইজ ল
জেরক্স
আমি পিডিএফটা দিয়ে দেবো করে নিও
may I just come?
দেওয়া আছে কিপটে হয়ে গেছে না কিপটে হয়ে গেছে কিপটে হয়ে গেছে Malad,
May I just come back, my lord?
yes. Malad, the first, Malad, if I may take your lordship's, Malad, to Malad, the points taken in the writ petition, Malad, and Malad, how we have dealt with it, Malad, in the report. So, Malad, if your lordship kindly take the writ petition and our report side by side, Malad, kindly see, Malad, the case made out. Well, kindly takes page 7, paragraph 13. 13 and 14. This is the first point taken. That the petitioner was granted higher marks than the private respondent. That your petitioner states that after completion of the inquiry in respect of the applicants, including your petitioner and the private respondent number 6 herein, the comparison in respect of all the applicants was conducted, and thereafter, on a score-based inquiry on offline module, your petitioner was granted 95.66 out of 100 marks, and the private respondent number 6 was granted 91.66 marks out of 100. Your petitioner states that after granting the score of 95.66 to the petitioner and 91.66 to the private respondent number 6 hearing, the subdivisional controller instructed your petitioner as well as the private respondent number 6 herein to appear before the district level fair price shop selection committee with the relevant documents in support of their application for FPS dealership. So this is the first point taken, that the petitioner had obtained a higher marks. Now, my lord, in reply to that, your lordship will kindly take paragraph 17 of my report. Score sheet টা বার করে দাও। My lord, page 11, paragraph 17. Yes. It is stated that, paragraph 17 I am placing. It is stated that the instant writ petition was filed by the petitioner on a misconceived notion that he scored 95.66 marks in the score-based inquiry system The petitioner made bold allegations of unilateral reduction of his marks by the answering respondent number 5 without any basis whatsoever. As per the averment made in paragraph 18 of the instant writ petition, such alleged reduction of 5 marks was made in the first week of June 2023. The petitioner did not even care to disclose the source of his alleged information and made an attempt to mislead this honorable court into staying the appointment of the respondent number 6 against the said vacancy. Now, my lord, in support thereof, your lordship kindly takes paragraph page 31 of the report. Page 31. Copy anything. Now, my lord, your lordships will find, my lord, this has already been placed by my learned friend several times. Your lordships will find that the petitioner and the private respondent had got marks 71 and 71 before it moved on to the stage of DLF-SSC, where there was a change in marks and accordingly respondent number 6 scored higher marks. Therefore, your lordship will find that the first submission, apropos the writ petition, not what is being submitted at the bar, what case they came up before your lordships, my lord. The case was that I had scored higher marks, but the score was reduced, putting me in a disadvantage, my lord. So, my lord, paragraph 17 and page 31 belies that submission, that any such disadvantage was caused. Now, your lordship will take another 2 paragraphs from the writ petition, paragraphs 17 and 19 of the writ petition. This is their next point taken with regard to the approach road.
Paragraph 17.
Paragraph 17, paragraph 17 and 19, yes. Your petitioner states that when your petitioner was waiting for the said FPS license, since in all respect your petitioner is the best candidate, your petitioner came to know that some people of the locality raised an objection to the effect that the approach road of your petitioner's proposed shop come go down, objecting to the effect that if the license is being granted to your petitioner, that will cause problem to the graveyard, since in the approach road there is a graveyard. Then 19. Next page, 19.
Yes.
Your petitioner states that your petitioner also came to know that during the subsequent inquiry, the approach road of the petitioner's shop come go down is 7 feet, though actually of the approach road of your petitioner's shop come go down is not less than 8 feet. And in terms of the score-based inquiry on offline module, the 5 marks has been awarded for the approach road from 8 feet to 10 feet. And since your petitioner's approach road is not less than 8 feet, your petitioner was granted 8 marks. However, in an arbitrary, unreasonable, and unfair manner, with malafide intention, the subdivisional controller conducted subsequent inquiry and deducted 5 marks from your petitioner's score. Thereby, the petitioner at serial number 2 for grant of FPS license in respect of the subject vacancy. Now, my lord, in response thereto, kindly take paragraph 19 of my report.
Yes.
Page 12. Furthermore, the allegations regarding the reduction of marks due to complaints in connection with the approach road to the shop of the petitioner do not merit any consideration, as the width of the approach road was found to be sufficient for loading and unloading of food crates during the field inquiry of both the petitioner and the respondent number 6, and the notification dated 17th of August 2021 do not provide for award of any marks on the criteria of availability of suitable approach road to the godown cum shop offered by the candidates. And my lord, again, if your lordship kindly takes page 31, there is score sheet, your lordships will find that there is no heading for approach road for granting of any marks. Therefore, this second point taken in the writ petition, there is no basis at all. So, my lord, since there is no provision for granting any marks, there is no question of deduction of any marks, as my lord tried to be made out in paragraph 19 of the writ petition.
Yes.
Now, my lord, while I was reading paragraph 19, your lordships has found that the petitioner has made a reference to a second inquiry. This reference your lordships will also find in paragraphs 20 and 21 of the writ petition also. That is at page 10.
Yes.
Well, kindly takes from the middle of paragraph 20 and also middle of paragraph 21. I'm reading from the middle of 20. However, Malad has got however only to deprive. It's in the fourth line. Fourth line. However, only to deprive the petitioner to get the said FPS license and with the malafide intention at the instruction or dictation of the subdivisional controller. Subsequent inquiry was conducted in respect of the petitioner's shop come go down and without any rhyme and reason in an arbitrary and unreasoned and unjust manner. Approach road of the petitioner's shop come go down was mentioned 7 feet, thereby deducting 5 marks obtained by the petitioner, which is clearly violative of the petitioner's rights protected under Articles 14, 19, 1G and 21 of the Constitution of India. Then last line of that page, that from the middle of paragraph 21, with the malafide intention.
Yes.
Malafide intention, petitioner's approach road has been shown 7 feet in the subsequent inquiry, though the actual wide of the approach road of the petitioner is 8 feet, so and so forth. So there, the case is that there was a second inquiry in which the marks was deducted. Now, my lord, if your lordship kindly takes our response at paragraph 18 and 19 of the report. That is at page 11. It is stated that the averments made by the petitioner in the instant writ petitions are false, since the office of the respondent number 5 awarded 51 out of 75 marks to both the petitioner and the respondent number 6 from the score sheet of all the candidates which has been disclosed by the answering respondents in the instant affidavit. It would be evident that such marks were awarded to all the candidates on 9th of May 2023 and there was no change in the marks of any of the candidates as on first week of June 2023. And paragraph 19, my lord, I have already read before your lordship, my lord. So I'm not reading it again. So, my lord, there is no indication in anywhere in the records that there was any second inquiry and therefore there was no scope of reduction of any marks. Now, my lord, the last of the points made out in the writ petition, your lordship will find at paragraphs 23 and 25. Not last, second last, because there's a point of house also. Character of land also is there, which is the fifth point. But kindly take paragraph 23 and 25. 23 is page 12. Your petitioner states that the godown of the private respondent number 6 herein is located or situated in a narrow lane where the concerned distributor of the said subdivision cannot reach with his truck for delivery of ration articles following the doorstep delivery. Whereas the godown of the petitioner is located or situated adjacent to the main road and there is more than 8 feet wide road in front of the petitioner's godown and concerned distributor will easily and hassle-free reach there to deliver the ration articles with loaded truck following the doorstep delivery. Then 25. Page 13, paragraph 25.
Yes.
Your petitioner states that your petitioner came to know that the size of the godown of the private respondent number 6 herein is a small room and also less than 600 square feet, whereas size of the godown of the petitioner is more than 800 square feet, and your petitioner can store the ration articles in his godown properly. Without considering the same, the subdivisional controller so and so forward the file of the private respondent number 6 herein to the higher authorities of the Food and Supplies Department for approval of the SPS license against the said vacancy notification dated 26 September and subsequently offered letter has been issued, which is arbitrary, unjust, illegal, and also violates so and so of the Constitution of India. Now, my lord, kindly takes our response at paragraph 25 of the report. Page 14.
Yes.
It is submitted that the instant writ petition is thoroughly misconceived. The petitioner has filed the instant writ petition with incorrect and unfounded facts. The instant, but I'm sorry, it won't be 25. But there's mistake. 24, I'm sorry, 24. Lastly, the allegation of the petitioner that the godown offered by the respondent number 6 is smaller than that of the godown offered by the respondent is also false and incorrect, inasmuch as the godown as well as the sales counter offered by the respondent number 6 is bigger in size than that of the petitioner. That when I place the inquiry report, it will be clear from that also. Now, the last of the points taken will be that point of house, which I'll deal with separately. Now, your lordships have found, एक बार report तो देखिए my lord, the inquiry reports, my lord, that I have annexed. My lord, one of them is starting at page 16 and the other one is at page 22. My lord, 16 is that of the writ petitioner. Your lordships will find at page 18 the dimensions of the godown so offered. Your lordships will find at serial number 51 B that the dimension of the storage godown, this page 18 is of the petitioner, is 649.75. Malad has got it, Malad?
Yes.
And Malad, that of the go down. Shopta হচ্ছে না এটা তো টোটালটা করা নেই না টোটালটা কত বল মানে I'll give the total of the sales counter also. Anyway, Malad, kindly I'll show that. Kindly, Malad, takes the in comparison to the storage go down. Kindly takes page 25. 6 or 7. So reported 6 or 7. Malad has found Malad page 25, 51B. The dimension of the storage go down of the private respondent is 724, which your lordship can discern, Malad, is much bigger than that of the petitioner. And Malad also kindly takes paragraph 6 and 7 of my report. Malad, I have given the area of the shop counter also. Page 4, paragraph 6. The petitioner applied against the said vacancy on 14 January 23. The petitioner fulfilled the financial eligibility criteria as mentioned in the said vacancy. Furthermore, the godown offered by the petitioner against the said vacancy had an area of 649. The sales counter offered by the petitioner against the said vacancy had an area of about 270 square feet. Kindly mark this, my lord. And the character of the land of the godown cum shop offered by the petitioner was constructed was bastu on the date of the field inquiry. The inquiry officer did not find any lacuna in the candidature of the petitioner so and so. Then kindly take paragraph 7. On the other hand, the respondent number 6 applied against the said vacancy on 1st February 23. The respondent number 6 also fulfilled the financial eligibility criteria as mentioned in the vacancy notification. Furthermore, the godown offered by the respondent number 6 against the said vacancy had an area of 724 square feet. The sales counter offered by the respondent number 6 against the said vacancy had an area of 283 points. Kindly mark this. So therefore, the sales counter of the private respondent was also bigger than that of the petitioner.
What is the requirement? 400 and 200.
Malad?
Requirement is 400 and 200.
400 and 200. And the character of land of the godown cum shop offered by the respondent number 6 was constructed was bastu on the date of field inquiry. The inquiry officer did not find any lacuna in the candidature of the respondent number 6 either. Thus, he recommended the candidate respondent number 6 should be considered against the said vacancy. Now, this recommendation, Malad, is being given a lot of weightage by the petitioner. But your lordships will find in both the forms of the petitioner as well as the respondent, your lordships will find, if your lordship kindly compares page 20 and page 26.
Yes.
Well, page 20 is that of the petitioner.
Yes.
Kindly, my lord, take the first comment that is pertaining to the land. Now, my lord, before that, your lordships will kindly find anywhere under every heading, like for example, at page 18, serial number 49. This just for example, I'm showing, not that much turns on it. For example, 49, where the topic ends, there's a space for comments. Serial number 49. Since everything is not applicable in that heading, comment is not applicable. Then part 5 is storage go down and office details, where that ends at serial number 58. There is a place for comments. Then part number 6, possession of storage go down. At serial number 64, there is a place for comments.
Yes.
So my lord, under and serial number 67 is the overall comments. So my lord, it is neither recommendatory in nature nor giving any special preference to anyone. A person has conducted an inquiry and he is giving his remark what he has found. If he finds 6 people suitable, he will write that this person is suitable. It has nothing to do by saying that the inquiry officer has chosen the person, and no right is being created by these comments. So my lord, kindly take page 20, the comment. Page 20 is the comment apropos the petitioner that the applicant has submitted all necessary documents like ROR of land, photocopy of deed paper, etc. As the land record is found that the said land as well as the godown also in the name of the applicant himself. There's serial number 64, and then serial number 67 is that the applicant has complied all the GOs as required. As far as the godown condition and location are concerned, it is most convenient to the beneficiaries of the projected service area. Considering all those aspects, the applicant is completely prepared in all segments and most suitable, competent candidate among all. So this application may be considered for recommendation of the new FPS license. And my lord, kindly takes 25th of March 2023, that is the inquiry report of the private respondent. Kindly takes my lord, page 26. The corresponding comment, my lord, serial number 64 at page 26, that submitted ROR of the land record and photocopy of the deed. And at 67, it is said that overall condition of the godown and sales counter is satisfactory. The applicant has complied all necessary GOs as per required. The applicant has submitted all necessary documents. So considering all those aspects, this application may be recommended for issuance of new FPS license. So my lord, there is no change in weight of the recommendation or the comments, because he finds everything is in order and he says he is also suitable. Both is recommended. Now, coincidentally, this is in March. Therefore, he did not have the occasion to inspect that of the petitioner, and the petitioner inspection is in April. So by that time, he has done some other. In his opinion, he thinks that he might be a bit more suitable. But my lord, when the marking system is applied, which is applied for everyone, it is found that both are getting 71 marks.
Yes.
Now, my lord, the difference occurs when the DLFSSC gives 2 marks more to the private respondent. Now, my lord, as far as DLFSSC, my lord, is concerned, but I'll come to that point because I'll have to show the provision with regard to that also, which my learned friends have also shown. But my lord, the point I started with showing the wrong pleadings in the writ petition, the case made out in the writ petition, his case can go at best what he has pleaded. It is immaterial what he now tries to argue at the bar, yes. But we'll all go by, my lord, the petition and the pleadings in the writ petition. So, my lord, as of now, the pleadings that I have shown, my lord, that is in paragraph 13, 14, 17, 19, 20, 21, 23, and 25. Apropos to that, my lord, I want to cite one decision which says that the points have to be pleaded by the petitioner, and the writ and the counter affidavit is not only the fact but also the evidence in proof of such facts has to be pleaded and annexed to it. So, my lord, it is their onus to make out a proper case. Now, my lord, in this regard, if your lordship kindly takes 1988, volume 4, SCC 534, my lord, a copy, my lord, is already there in the file, my lord. If required, we'll give another, my lord. 534, Bharat Singh. Your favorite. I will kindly take paragraph 13 at the continuing portion at page 543. এগুলো কি সবকটাই দেওয়া আছে? Yes. 12 এখানে আছে? Yes, my lord, kindly, my lord, skips over the first 6 lines. Kindly takes the sentence at page 543 from in our opinion. Okay, got it. In our opinion, when a point which is ostensibly a point of law is required to be sustained by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by the evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such facts is not annexed to a writ petition or to the counter affidavit as the case may be, the court will not entertain the point. There were these random points taken in the writ petition, those should have been backed by the writ petitioner by appropriate annexures and evidence. By merely saying that I got 95 marks, the private respondent got 96 marks, 91 marks, these are all making rash statements, creating a situation to invite an affidavit from the state and building that case from the affidavit itself. Then kindly skips over 2-3 lines, then kindly take the sentence from while in a pleading. In the same page 543, while in a pleading. That is, a plaint or a written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the fact but also the evidence in proof of such fact have to be pleaded and annexed to it. Malad, in support of this point, Malad, another only one more judgment I'll show, that is 2012, volume 12 SCC 133. Malad, that is the effect of misleading and inaccurate statements before the court. Malad, kindly takes from paragraph 44. Malad, may I place it, Malad? Paragraph 44. Malad, generally, I would not take your lordship through these judgments, but Malad, this is one of those writ petitions which we have come across as filled with inaccurate facts. Their entire plinth is on a wrong premise. Can you take Malad, paragraph 44?
Yes.
The appellants have not approached the court with clean hands and are therefore not entitled for any relief. Whenever a person approaches the court of equity in the exercise of extraordinary jurisdiction, it is expected that he will approach the said court not only with clean hands but also with a clean mind, a clean heart and clean objectives. Thus, he who seeks equity must do equity. The legal maxim, jure naturae acquim est neminem cum ulterius detrimento et injuria fieri leucoplaterium, means that it is a law of the nature that one should not be enriched by causing loss or injury to another. The judicial process cannot become an instrument of oppression or abuse or a means in the process of the court to subvert justice for the reason that the court exercises jurisdiction only in furtherance of justice. The interests of justice and public interest coalesce, and therefore they are very often one and the same. A petition or an affidavit containing misleading and or inaccurate statement only to achieve an ulterior purpose amounts to an abuse of the process of the court. In Dalip Singh versus State of UP, this court noticed an altogether new creed of litigants, that is dishonest litigants, and went on to strongly deprecate their conduct by observing that the truth constitutes an integral part of the justice delivery system. The quest for personal gain has become so intense that those involved in litigation do not hesitate to seek shelter of falsehood, misrepresentation, and suppression of facts in the course of the court proceedings. A litigant who attempts to pollute the stream of justice or who touches the pure fountain of justice with tainted hands or is not entitled to any relief, interim or final. The truth should be the guiding star in the entire judicial process. Every trial is a voyage of discovery in which truth is the quest. An action at law is not a game of chess. Therefore, a litigant cannot prevaricate and take inconsistent positions. It is one of those fundamental principles of jurisprudence that litigants must observe total clarity and candor in their pleadings. Malad, kindly Malad, remembers paragraph 14, because they have made contradictory statements also. I'll show in my next limb of submissions that no opportunity was given to them by the DLFSCC, and this has been argued also twice or thrice by my learned friend. I'll show from their own pleadings that they were called for the documents to be produced. Malad, I'll conclude this by paragraph 49, a single sentence paragraph. In view of the above, the appellants have disentitled themselves for any equitable relief. But this is the ultimate result of inappropriate and misleading statements. Now, Malad, it is also not a case where they were under some wrong premise, they were under some misconceptions, and upon receiving our report, they understood that no, I was not awarded 96 marks. I was in fact awarded 71 marks, and accordingly, they sought a amendment of the pleadings before your lordships. We exception in fact, when we filed the report, Mallard, it is recorded in one of your orders that they do not wish to file an exception. So they have accepted our facts, but after accepting our facts, they are not sought and come before your lordship saying that I was under some wrong impression and therefore I want to amend the pleadings. Your lordship will find their recording in the order dated 15th of March 2024, where your lordship will find in the fourth paragraph, 15th of March 2024. In the fourth paragraph, সম্রাটদা তো বসে আছে, কোনো কার জন্য টাইম নিচ্ছে ও ইডিয়েট? লিডার বসে আছে নাকি? Millard has got the order of 15th of March, Millard. অন্য এটারই তো।
Yes.
Kindly take the fourth paragraph. Mr. So-and-so learned advocate for the petitioner at the outset submit that his client will not file any exception to the report filed by the state respondent. The Millard, facts pleaded by me, Millard, are not controverted by the petitioner. Now, Millard, your lordship will kindly remember. Publish. আরে তো আদার সাইড টাইম নেবে। ঠিক আছে করে ওখানে আছে জুনিয়র আছে তো। Now, my lord, one point has been argued repeatedly that no opportunity was given by the DLFSSC to the petitioners to produce the appropriate documents, and behind their backs 2 extra marks were awarded to the respondent number 6. Now, my lord, this particular point being urged, my lord, your lordship will kindly once again take the writ petition, paragraph 14 and 15. Which belies their own submissions because their pleadings are to the contrary. Paragraph 14, your lordship got, my lord, page 7. Now, my lord, this paragraph, my lord, I have read once, I am reading it, my lord, again. Your petitioner states that after granting the score of 95.66 to the petitioner and 91.66 to the private respondent, the subdivisional controller instructed your petitioner as well as the private respondent herein to appear before the DLFSSC with the relevant documents in support of the application for FPS distribution. Your petitioner states that as per instruction of the subdivisional controller, your petitioner was present at the scheduled date, time and venue along with the relevant documents in support of the application submitted by the petitioner. Therefore, there cannot be any question that he was present with his documents to his satisfaction before the DLFSC, who at that point of time gave 22 marks to the petitioner and 24 marks to the private respondent, making the private respondent's marks 2 marks more than that of the petitioner. Now, my lord, this is, my lord, from the writ petition. Now, my lord, the other points which are argued by the petitioner, my lord. The next is, my lord, that clause 7B2, that being a graduate, whether he was entitled to a precedence over the other person or not.
Yes.
Now, my lord, in this regard, if your lordship kindly takes the memorandum of 17th August 2021, so the separately দিয়েছিস তো 17th August 21, কিছুই তো জানিস না দেখছি তাই জিজ্ঞেস করছি।
Yes.
My lord, kindly takes, my lord, the memo of 17th August, my lord, probably it was handed over separately by Mr.
Yes, it is.
Yes. My lord, kindly takes from serial number 5.
Yes.
At the 3rd page. My lord, from 5 the mechanism has to be seen that each member of the DLFP-SSC shall evaluate the applicant on the scale of 0 to 25 to determine the suitability of a candidate from among the eligible applicants. the average of the marks received by the applicant shall be the gross marks secured by him. The DLFP may, if considered necessary, take personal interview of the eligible applicants to find the suitability for the vacancy. The DLFP make its recommendation on the basis of the total marks of the SCFS plus gross marks given by the committee. Therefore, paragraph 5 is the marks by the DLFP, who will give a marks out of 25. Then 6 is the computation of marks, that the marks given by SCFS plus the marks of DLFP, which brings to a total score. Then comes paragraph 7.
Yes.
That the DLFP or the subcommittee, while giving its report, after computing the mark, the report is ready. Then what they can do, may take into following the further consideration. What is it? A. In the case the same total score, the applicant in the individual capacity will get the preference. So first criteria is, after the exercise in paragraph 5 and 6, there has to be a total score. Then paragraph 7 comes into play. Then B. In case of 2 or more individuals with same or similar credential qualify for the particular dealership. Kindly pause here for the moment. Therefore, then the 7A step, when it is done and the individual person is given the preference, then B comes. Then if we are left with 2 individuals, then the preference would be given to the following in descending order. Roman 1, single woman, unmarried, widow, separate with a court decree or order. And Roman 2, graduate, unemployed individuals. And then C, if 2 or more applicants get same score, the youngest among them will get the priority. That is not relevant for our consideration. Therefore, first 5 is there, then 6, then 7. We are not in 7 at all. So therefore, A and B are not important for us. But since it has been argued, I am having to justify that after 7, then also it is, this course may be followed.
Okay, after gross marks, it appears that the gross marks are
Total. Equal. Then only
7 appears.
7 applies. Then after assuming here both got same marks, then 7 is applicable. Then also, my lord, first it has to be seen both are applicants or not, individual or not.
7A, then B, then C.
Then B, and no, then B, and C is completely separate.
Yes.
C is if more than 2 have total score, then the younger one will be. If more than 2 are not there, then the person will not be able to say that I am younger, give it to me. Then he will have to be either a single woman or a graduate.
Yes.
So, my lord, in our case, my submission in summation is that in our case, the stage of paragraph 7 itself has not reached. Because page 31 will show that one got 93 and the other one got 95. Therefore, there was no requirement to undertake the exercise in paragraph 7. Now, my lord, I'll just quickly, my lord, deal with that point, my lord, from the control order also. The point that the inquiry officer's comments carried a lot of weight. My lord, here, your lordship will kindly take, my lord, the control order that I've handed over, my lord. Your lordship will kindly take paragraph 20, subparagraph 3. Well, one is it's a rural, right? এটা তো রুরাল কন্ট্রোল অর্ডার হ্যাঁ না তোমারটা তো রুরাল অ্যাপ্লিকেবল তো Malad will kindly take the rural control order, Malad, which is not the one is urban and one is not mentioned so, Malad.
PDS, one is 2 PDS.
Malad, the one which does not have urban in the heading.
Yes, that is rural.
Yes. Non-urban, if we may say that. Now, Malad kindly takes 20 subparagraph Roman 3. Well, my endeavor is to compare the weightage of the inquiry apropos to that of the DLFP. This is my only endeavor. That is why I am troubling your lordship. Well, it should be at page 16. The pagination is at the bottom.
Page 16.
But I'm only hoping that both the paginations are same, Malad.
Yes.
But I hope Malad page 16 is starting with a Roman 3 as a paragraph, Malad.
No. Page 15 is the last Roman 3.
Malad, subject to the date sheet.
You are reading Roman 3?
I am reading para 20, Roman 3, yes.
Roman 3?
Yes. Subject to the date sheet. Roman 3 is starting with subject to the date sheet.
Yes.
Yes. Kindly in that Roman 3, kindly skips over the first 4 lines. Kindly takes the sentence starting from on receipt of the application in Form C.
Yes.
On receipt of the application, application in Form C along with Annexure 1, requisite fees as prescribed in Schedule A and corroborating documents as per the checklist within the stipulated period, the subdivisional controller food and supplies shall process the case and get the case inquired into by the competent officer or group of officers and send a report in Form L with his comments in Form M to the concerned district controller. So the role of the inquiry officer is restricted to giving his comments in Form L, which is the form that I have shown. Form L, yes, Form L, which I have sent. M is the comment of the SCFS. No. I'm confused. As far as the inquiry officer is concerned, that is Form L. That is the form which is at page 16 and 22. Additionally, kindly takes Roman 4. Next to next page, it should be, Malad.
Yes.
Notwithstanding anything contained in subclause 3, if the state government deems it necessary in the exigency of public interest to expedite the process of engagement of a dealer, it may by an order take up its control and the engagement of the dealer at any stage of the processing of the application, and if necessary cause the inquiry referred to in subclause 3 by the inquiry committee comprising of an officer or group of officers of the food and supply department duly authorized in this behalf and the concerned SCFS, and on receipt of the report under subclause 3 or this subclause may, as the case may be, grant approval for engagement of the most suitable candidate for filling of the vacancy. This is in case of emergent situation. That also he will only do the inquiry, send his comments, and the state will take the steps. Then kind of text 4A, the next one. For the purpose of choosing the most suitable candidate, the state government may by an order constitute a DLF PSSC and shall also devise a marking system covering the size of godown, accessibility of the shop from main road, area of the location of shop in the manner specified in the said order. Therefore, the weightage is important as far as the DLFP is concerned. The job of the inquiry officer is to do the inquiry and give his comments in Form L. No weightage is as such attached as far as the inquiry officer is concerned. The difference here is that of an inquiry and that of a decision. Because your lordship will find in Roman 3, which I read, that paragraph ends with that the district controller shall place the matter before the district fair price shop selection committee and forward their decision. So one is only seeing what is there and one is applying the mind and taking a decision. So my lord, the weightage is there as far as the DLFP is concerned, and the inquiry officer is only there to go and ascertain the facts. It is not a recommendatory authority.
Now, then who is giving the first marks? That is the after inquiry.
So my lord, after inquiry, my lord, your lordship will
I
find.
understand the inquiry officer has given the details about the inquiry.
Yes.
And who given the mark? The first marks about the inquiry.
My lord, the first marks, my lord. My lord, the marks is entered from the inquiry. Like what is appearing from the inquiry itself. My lord, the processing, your lordship will find at serial number 3.
Yes.
But since this is the procedure, my lord, we'll have to find the answer there, my lord. Towards the middle of Roman 3, your lordship will find that the subdivisional controller food and supplies shall process the case and get the case inquired into by the competent officer or group of officers and send a report in form L with his comments in form M.
Form M is the marks.
Form L is the inquiry officer's report and with his comments, meaning the SCFS's comments in form M to the concerned DCFS. So, my lord, the first marking is by the SCFS because he is the one who is processing the applications. And then this is forwarded to the DCFS, who then places it before the DLFP, who is separately giving the marks as on the date of their consideration. And this marks of the DLFP is entered by the DCFS, which I can show from page 31.
Okay.
If your lordship takes page 31.
No, it is in Geo 17th August 2021. It is clear at 2. The concerned SCFSC.
Yes, Malad, I'm grateful.
Shall allocate the mark.
Grateful, Malad.
Shall allocate the mark. Yes.
And Malad, it is also appearing from the page 31 also, Malad. Yes. Now, Malad, the last of the points taken is that the land of the private respondent was ouch in nature. Now, Malad, in this regard, their pleading is there, Malad. I'm not taking your lordship, Malad. That is at paragraph 24 for reference. Your lordship will kindly take, Malad, our report. Paragraph 21. Malad, page 13.
Paragraph 22 or 21?
21. 21 and 22. 21. The petitioner has not challenged the validity and the validity of clause 32 of form C of in the instant writ petition, and thus the petitioner who participated in the selection process without any demur whatsoever after becoming unsuccessful in the selection process are stopped from raising the question on the manner of selection adopted by the answering respondents and further stopped from challenging the eligibility criteria of the selection process against the said vacancy. It is pertinent to mention here that Form C has been amended on several occasions in 2023 and 2024. However, for the adjudication of the instant list, the Form C, which was in vogue on the date of the notification of the said vacancy, will be appropriate. So this we have annexed at page 43. Kamalat kindly takes page 43 and then turns over to page 44. Kindly takes entry number 32 in the middle of page 44. So this is the application form, Form C. Your lordships will find that what was required is character of land of the premise, vastu, commercial or agricultural, etc. Therefore, my lord, when the person was applying, there was no bar as far as applying as an agricultural land is concerned. What I'm trying to say is that maybe ultimately the land will not be considered if it remains to be agricultural. But there is no bar at the threshold. Meaning thereby, my lord, if it says that I will entertain only if it is non-agricultural. That is not the case. Today, this part has been amended. But when this application was made, that those amendments were not there. That is why we had to give the unamended Form C. So there is no bar at the threshold. But your lordship will find at the time of inquiry, it has been found that a conversion has been made and the land is now non-commercial. This also my learned friend had placed at page 46. And my lord, I remember your lordship specifically marked the dates that the conversion is prior to the date of inquiry, because this is of February 2023 and the inquiry was in March 2023. And also, my lord, 22 of the report, which will just conclude the point, that is further stated that the respondent number 6 applied the conversion of the nature of his land from house to VT from the statutory authority under so and the said conversion was allowed by the statutory authority on 23rd of February 2023. Yes, and another point, my lord, is that your lordship kindly take the advertisement. Advertisement. My lord, at page 36, writ petition page 36. Yes. Well, this is probably the point argued today. Romans 7a. That the documents regarding possessional's right over the proposed place of business, that in case of ownership or share ownership, photocopy of record of rights, registered deed of conveyance, purchase gift in the name of applicant, etc. can be given. The point of the petitioner is that ROR has not been given. Now, my lord, what he is not reading is thereafter the other alternatives are there which can be given. And my lord, your lordship will find that the deed of conveyance, etc. can also be given in place of ROR. ROR itself is not a mandatory requirement.
No, it is the argument that the document placed along with the application by the private respondent is misleading and on the way of misrepresentation.
Now, my lord, I asked this question to myself, my lord. I am a statutory authority working within the four corners of the statute. The statute has not given me the power to call for or set aside or, my lord, impound a particular document because it is wrongly mentioned, wrongly described, or say wrongly stamped. I am not that authority. Yes. A document has been placed before me. I'll have to take it on a face value. There is a marking system on the basis of which I'll give the marking. If the persons on the touchstone of the requirement of that vacancy fares well and a particular marks is there, I'll award that marks. What is there in the recital and what is right or wrong in the deed, my lord, that is subject to, my lord, consideration by your lordship, my lord, is beyond my purview at least. If he feels that there is something wrong, he has to challenge it before the appropriate civil court, my lord. But I, as an authority under the Essential Commodities Act, I have no power to go into all that aspects, my lord. I only see whether the title is there or not, and whether that title, ownership, or right of occupation is commensurate with my advertisement or not. Nothing more. But same in the page 35 also, my lord, this point of highest educational qualification was taken, that the proof of highest educational qualification of the individual applicant should be given. My lord, but it is not a requirement as far as the marking system is concerned. It may be one of the documents which is necessary by us. But if I may draw an analogy here, my lord, I may ask for the EPIC card for identification of a person. But he being a voter or not may not be a requirement as far as my advertisement is concerned. So it may be for a different purpose altogether. So many times, my lord, our Madhyamik admit card is asked for by the authorities, but not because to see whether I passed in Madhyamik or not, but as a proof of my age. So, my lord, this requirement is not as a requirement as far as his eligibility is concerned. My lord, 3 decisions has been shown. My lord, I don't think, my lord, on facts there need to be distinguished, my lord. If required, I'll leave Mr. Bandopadhyay to take up that labor, my lord, because he has got the license. But my lord, what I can say, my lord, the points in those are that whether, my lord, when your lordships will interfere with my action, my lord. But here your lordships are only not your lordships are not looking at the decision itself, but in judicial review, your lordship is looking at the decision making process. My lord, I have endeavored to show from the documents that there was no malice or arbitrariness as far as my decision making process is concerned. Okay. I have looked into his documents, I have looked into the factual position, and according to that, I have given the marks. The DLFP has considered that the respondent had a better go down, and accordingly 2 marks has been given to them. That also from the area I am showing, even from a layman's view, if the go down of the private respondent is a bigger in size, no wrong has been committed by giving a higher marks to that person. So, there is no arbitrariness as far as my decision making process is concerned. That's the point. More or less, these are the points I have tried to call out from the arguments of the petitioner. Okay. Now,
I have another fixed matter today.
The second
Today.
200
And 1-3 here.
কন্টিনিউ করা দরকার ছিল। Tomorrow, now where is the private respondent?
Mr. Bandopadhyay.
Tomorrow,
Great.
first up. Tomorrow first up.
Well, kindly excuse me for tomorrow because I have completed my order.
Yes. এটা এমনি আলাদা করো।
Green. Green level. Green level. 100%.
May it please your lordships.
पेपर शुरू बताओ, पेपर शुरू बताओ।
My lord, kindly
So
take
these
the.
are the 34 applications.
Correct, correct.
34
Section
applications.
34.
Section 34 applications.
My lord, before Mr. Mukherjee commences his arguments, I raise a point of maintainability of his petition. And my humble submission is that the point of maintainability be decided first.
So you on which matter? On all three matters?
On 698.
On 698. Where is this?
That is 135 of
Okay,
2020.
item number 1.
Yes, my lord.
What is maintainability now?
In this matter, you want to raise the point of maintainability?
Yes, my lord.
This is the application under section 34
filed by
of arbitration and conciliation.
Yes, my lord. Filed by Mr. Mukherjee's client under section 34.
Yes.
In the month of August 2016.
Yes.
So I raise a point of maintainability. This petition is barred by law of limitation.
This petition is barred by law of limitation.
Yeah, especially under section 34(3) of the Act 1996.
Mr. Mukherjee, he raised the point.
My lord, I'll tell your lordships, my lord, this matter had been heard earlier also. My lord, I had concluded.
This matter,
Yes,
one.
yes, before my lord Justice Bhattacharya. My learned friend, my lord, and now, my lord, we have a point of limitation, my lord, all this while.
My lord, I have raised this point earlier also.
I'm not saying my learned friend has not, but my lord, matter had been proceeded with. It's there, my lord, in his.
So what happened there? You have started the matter along with the limitation point.
Yes, my lord, it wasn't even, my lord, argued the limitation. I had, my lord.
No, it was never argued on point of limitation. Mr. Mukherjee has argued on the basis of his petition only.
Mr. Mukherjee, what can be done? Let me hear out.
Yes, yes, kindly.
Let me hear out him first. Okay, you just raise the point. Point of limitation.
Yes. My learned friend will only show one thing, that in his affidavit he's raised this point.
Yes.
Whether it has been raised or not means it's a point of law, miss.
Okay. You proceed. You proceed. What you have on proceed.
Before I proceed, my lord, I would like to invite your lordship's attention to various sections of the Act.
Arbitration. Anand.
Mr. Midora, do you have arbitration? Sorry.
Yes.
Section 21C.
Yes.
It relates to arbitral award, includes the interim award.
Yes.
So this is a final award. There is no dispute about that, my lord. The another is section 21D. Arbitral tribunal means a sole arbitrator or a panel of arbitrators. In my case, my lord, it's a single arbitrator appointed by the learned Honorable High Court on 30th of March 2012. Next is 21H, my lord. Party means a party to arbitration agreement. Mr. Mukherjee and I, we are both parties to the agreement, my lord. Chapter 6 deals with making of arbitration award and termination proceedings, my lord.
Here I would refer to 31(1), my lord. Section 31(1).
Yes.
Arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. The award was made in writing and it was signed by the tribunal. There is no dispute about that. 31(4), my lord. The arbitral award shall state its date and place of arbitration as determined in accordance with section 20, and the award shall be deemed to have been made at that place. So this is an award against which an application is filed. There's no problem about that. 31(5), my lord. After the arbitral award is made, a signed copy shall be delivered to each party. Both the parties have received the copy of the award, and both the parties have filed an application under section 34, my lord. Mr. Mukherjee's application being 698 of 2016, and mine application is 822 of 2016, my lord.
Yes.
The new number is, my lord, 138 of. Then comes section 32, my lord. The arbitral proceeding shall be determined by the final arbitral award or by an order of the arbitral tribunal under section 2. So once an award is made, section 32 is over, my lord. 33 relates to certain corrections, which has never been a case here. There was no application for correction, typographical or calculation, something like that. Then comes 34(3), my lord. This is the most important. Have I got, my lord?
Yes.
And lordship got? An application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award. If a request had been made under section 33, from the date on which that request had been disposed of by the arbitral tribunal, provided that if the court is satisfied that the applicant was prevented by sufficient cause from making the application within the set period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter.
Yes.
Now, Milord, I will draw your lordship's attention to the award. It is in the petition part 2. It starts from page 120 and it ends at page 172, my lord.
Yes.
I'll refer to page 172, my lord. Absolutely end of the part 2. The arbitrator has signed the award and it was signed on 19th of May 2016. So the final award was delivered, published by the learned arbitrator on 19th of May 2016, my lord.
Yes.
Now, my main dispute, my main point of maintainability is that this petition was not filed within the statutory period as provided in section 34(3) of the Act. Act number, part one. Yes, volume. If a lordship would refer to page 114 of their part one volume, my lord.
Yes.
Para 46, my lord. The petitioner further states and respectfully submits that the instant application is made within the statutory period available for challenging the award, and that unless orders as prayed for herein are made, the petitioner will suffer irreparable loss, prejudice, and injury. So here the petitioner submits that he has made this petition within the statutory period as provided under the law. Now, my humble submission is the petition has not been filed within the statutory period of 90 days. I'll come to that.
Yes.
As prescribed under section 34(3), although the petitioner has claimed in paragraph 46 of its petition to have filed the application within the statutory period, the signed copy of the award was received by the petitioner on 19th of May. And the petition under section 34 has been filed on 17th of August.
Seventh of August.
17th of August.
Registration 7th of August. देखो 7th of August. It was filed on 7th August.
17th August, my lord.
No.
Yes, my lord.
Date of 7th August 2021. Then it is not matching date. Very well.
That is on 91st day. Now we can calculate these 91 days, 13 days of May, 30 days of June, 31 days of July, and 17 days of August, which comes to 91 days. And they were supposed to file within 90 days. Now, had they made an application for condonation of this one day, or have they made a prayer in their petition for condonation of this one day, it could have been considered by the Honorable Court. But then they have neither made any prayer nor made any application for condonation. And the Honorable Court cannot suo motu grant condonation. As such, the petitioner is liable to be dismissed, since filed beyond the period of limitation prescribed in section 34, subsection 3. It is well settled principle that if the matter of doing a particular act is prescribed under the statute and the same is not followed, the action is a nullity in the eye of law. A petitioner who has failed to file the petition under section 34 within the first 3 months, that is 90 days, must take a leave of the Honorable Court and upon such leave being granted, and upon the honorable court being satisfied of the reasons shown, can be permitted to take the benefit of the additional 30 days. 34(3) says one has to file within 3 months, and then another period of 30 days have been prescribed. For this, the petitioner has to make an application for condonation, which has not been made in this case. The words of the proviso makes it clear, sufficiently clear, that the additional period of 30 days cannot follow as a matter of course and without the intervention of the honorable court granting the leave as contemplated in the proviso.
Yes.
For this, my lord, I rely on a judgment passed by the coordinate bench of this honorable court. Kindly come to page 7, my lord. Paragraph 10. I'm reading from the middle of the paragraph, my lord, after about some 7-8 lines. Since the petitioner received the impugned award on 27th of February, the prescribed period under section 34(3) of the Act expired on 27th of May.
Or from your reading? Paragraph 7.
4, 5, 6, 7, 8. 9th line of paragraph 10, my lord. Can I place it, my lord? Page 7, paragraph 10.
Yes.
Since the petitioner received the impugned award on 27th of February 2019, the prescribed period under section 34(3) of the Act expired on 27th of May. An important thing to note here is, my lord, this is for 90 days. Had it been 3 months, it would have been 26th of May, not 27th of May. Then the application under section 34 was filed by the petitioner on 18th of June. That is after 112 days. It has been fully calculated here, my lord, from the date of receipt of the award by the petitioner, and hence after a delay of 22 days. Section 34(3) contemplates that an application who has failed to file the application under section 34 within the first 3 months must take the leave of the honorable court, and upon such leave being granted and upon the court being satisfied of the reasons shown, can be permitted to take the benefit of additional 30 days. The words of the proviso makes it clear, sufficiently clear, that the additional period of 30 days cannot follow as a matter of course and without the intervention of the court granting the leave as contemplated in the proviso. The petitioner in this case did not take steps for seeking condonation of the delay of 22 days before the commercial court and allowed the said delay to continue till filing of the present application. Now, my lord, here the award was received on 27th of February. From 27th of February to 27th of May, if we calculated days, it comes to 90 days, precise 90 days. That's 2 days of February, 31 days of March, 30 days of April, and 27 days of May. It comes to absolutely 90 days. I mean, section 34(3) says of 3 months. and then 30 days. And the Supreme Court has stated in a number of judgments that the outer limit is 120 days. If the outer limit is 120 days, the inner limit will be 90 days because 30 days have been specifically prescribed. For this, my lord, I rely on a judgment of Honorable Supreme Court delivered in AIR 212019, Supreme Court 505. I have a spare copy. There are two things which I would like to specify here, my lord. Kindly come to page 4, my lord. Eighth line on page 4, my lord. Page 4, eighth line, my lord. It is to be noticed that the powers under section 34 of the Act can be exercised by the court only if the aggrieved party makes an application. The jurisdiction under section 34 of the Act cannot be exercised suo motu. So what I submitted earlier, that if there is a delay beyond 90 days, subject to a maximum of 30 days, if the petitioner makes an application seeking condonation, the court can consider and condone, may not condone also. But here in this case, no such prayer has been made, no such application for condonation has been made. Then kindly come to page 5. 13th line, my lord, from the top.
Yes.
The petition under section 34 was filed much beyond the outer period of 90 days. So that 3 months has been declared here as 90 days. And I refer to another judgment delivered by Telangana High Court in Food Corporation of India versus AP State Warehousing Corporation. Kindly come to page 4, my lord. Paragraph 5. Section 34 of the Act 1996 vests right in a person aggrieved by the award passed by the arbitrator to challenge the award before the civil court. The Act prescribes 90 days period of limitation to avail such remedy with a grace period of 30 days. So this 90 days is very clear, my lord. Calcutta High
Act prescribe 3 months and 30 days.
So what I am trying to submit, my lord, that 3 months is 90 days because outer limit is 120 days. If outer limit is 130 days, and if the additional 30 days beyond 3 months have been prescribed as 30 days, then the inner period will be 90 days only. I will show for 120 days also, my lord. So as far as 90 days is concerned, I have shown, my lord, Calcutta High Court judgment. I have shown Supreme Court judgment.
Yes.
I have shown this Telangana High Court judgment.
Very good.
I refer to a judgment of Honorable Supreme Court delivered in 20224 SCC 162. Mahindra and Mahindra. I'll give you a copy subsequent. Page 4, my lord.
Yes.
12th line from the top, my lord. Twelfth line from the top. The use of the phrase, but not thereafter, shows that the 120 days period is the outer boundary for challenge of an award. Now, if outer period is 120 days, the inner period is 90 days, because 30 days have been specifically stated in section 34(3).
Statute does not provide the 90 days. It says 3 months.
Fine.
Thereafter, 30 days.
But what I wanted to submit, my lord,
that on several
30 days, 3 months may be according to the English calendar month. It may be 88 days, it may be 90 days, it may be 90 days.
92 days or 91 days.
So for that also, I will show necessary order of the Supreme Court, my lord.
Okay. So today we don't have any time now.
My lord.
So Mr. Mukherjee, when can we done?
Any time, my lord. Any day. Other than, my lord, Monday, my lord, any day. My lord, I believe your lordship takes original sites on
Yes,
Friday.
on Friday.
Friday is fine. Friday, ठीक है? Friday.
My only humble request is, my lord, if it could be fixed at 2 o'clock, then at least we can have sufficient time. Mr. Mukherjee can also complete his submissions.
Friday, ठीक है? Friday.
This Friday?
Yes, my lord.
This Friday? At 3?
This Friday, another matter has been fixed, my lord.
Your matter is fixed.
Yes, my lord.
Then this Friday it will be taken. This Friday it cannot be taken. Then it will be not come on next Friday.
Again, my matter has been fixed there.
Next Friday, another matter is fixed.
On 5th, your lordship is fixed. My execution petition, EC 457. And on 12th, my another petition, APO 114, has been fixed.
Okay. So next Tuesday is the 9th. 3 p.m.
My lord, I'm fine, my lord.
You have no option.
My lord, if it's possible this Friday, because I don't know how long my learned friend will take, I'll take, my lord, 5 minutes.
I know. Let it fixed on Friday. If after your matter, this matter can be done.
Yes, ma'am.
No.
Okay.
No problem.
Very well.
At 2 p.m., my lord?
No, after this matter, at 3 p.m.
No, after my earlier matter, which has been fixed.
Yes.
After that.
Yes.
So the earlier matter,
Your
has
matter was fixed on 2 p.m.
2 p.m.
2 p.m. After your matter, that this matter will be.
No.
Okay.
I'm grateful, my lord.
ठीक है. What's the execution? So what?
ठीक है. हाँ. Time please. I mean, date sure. এইটা একটু রেখে দাও।
Friday কিছু নেই তো। এইটাতে কিছু নেই তো।
বইটা দিয়ে দাও। 9 তারিখ করছি না, ফ্রাইডেতেই করছি।
Your lordship earlier stated that your lordship will try to hear the execution petition after this. So can it be heard first and then execution petition?
Yes, because that's what your lordships observe.
Yes,
My lord, his
yes,
application is
That will
executed.
be better. So come on, at 2 this matter will be appear.
Yes.
First এটা দাও, তারপর ওটা। Okay, very.
Okay. Thank you.